Okay, great. It looks like we're live here and we have a quorum, so we'll gavel in. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 9th, 2021. We have, 12 bills on the docket here today. I'm just going to go ahead and read them in order. Senator Rosapep, you're first with Senate Bill 360. Then we've got Senate Bill 363, 364, 369, followed by Senate Bill 474, 488, 504, 394, 401, 402, 454, and we'll end with Senator Sidnor at 455. So with that, Senator Rosapep, you are up with Senate Bill 360. The floor is yours. I'm asked to unmute you, and here we are.
Thank you very much. Thank you, Mr. Chairman. I'm impressed to see these backgrounds. It suggests that some of you have law books. That's very impressive. That's cool. It's a pleasure to be with you. I'll be very brief. The fiscal note and the testimony that you'll be hearing from other people more expert than I really lays out the issue in detail. But the essence of it is that, as you know, the Secretary of State's office is responsible for basically the registration of notaries. We have 90,000 notaries in Maryland. It's an important part of our economic system. And all this bill does is create a special fund. They're already collecting fees for the service. We want to ensure good customer service. They need to invest, like everybody else, in technology and staffing to make sure they're able to provide good customer service. And so this would be very much like we have other regulatory boards in the state, like health boards, the nursing board, the doctor's board, et cetera, where the professionals pay a fee, the fee goes into a special fund, the special fund is used to provide the service. That's what the bill does. Thank you, Mr. Chairman.
Excellent. Short and sweet, just the way you like it. All right, so for your primary witness today, you have Mr. D'Ambrosia. You're up. How are you?
I'm great. Thank you very much. Thank you, Chairman Smith, Vice Chairman Wall-Stricker, and members of the Senate Judicial Proceedings Committee. My name is Nick D'Ambrosia. I am a principal broker for a company called Long & Foster Real Estate, which makes me the largest principal broker record in the state of Maryland, for what that's worth. But more importantly, I was a member of the 2018 Notary Work Group that studied the Maryland notary law and made recommendations for changes to that law. The 2018 work group was followed by another work group in 2019, which focused on remote online notarizations. So I've had some, besides real estate, the laws surrounding them, how they're regulated, et cetera. I urge the committee to vote in favor of Senate Bill 360, Notaries Public, Notary Public Fund, and Remote Notarial Acts. The Notary Public Fund will be used by the Office of the Secretary of State solely to cover expenses, including the implementation, regulation, administration, and enforcement of the law as a result of the 2019 legislative session in which Senate Bill 678 was passed. The Notary Public Fund will provide supplemental funding to the Office of the Secretary of State to cover the costs required to administer the new notary law. The work groups, when we had the work groups, we concluded that several things had to be done by the Secretary of State's office in order to make the process of notarization more viable. And part of it was to add additional personnel, to modernize technology, which goes ahead and rolls in the fact of the remote notarization. While it's not going to be a fix-all for everything, and I know the funds are going to be limited, I can tell you I do have some experience, and you'll hear more later on from another speaker who's supporting this. I've been a Maryland real estate commissioner for 16 years. I'm in my 16th year. I've been elected chairperson of the commission. I'm not speaking on behalf of the commission, but it's important that I tell you that I've been involved with the commission when it transitioned from being part of the state funding to having its own dedicated funds. And I can tell you that I experienced the things that the commission was able to do for the consumers in cleaning up complaints, expediting them, getting additional investigators online. And all of those things came from being able to be self-funded. And I believe that the Secretary of State's office will be able to accomplish a lot more on behalf of Maryland's consumers by going ahead and having control of those funds. I'd like to sum up by saying the work group was stunned to learn that 2 notary officers process applications, background checks, reference checks for 90,000 notaries public. You know, that's a huge number of people to go ahead and oversee, and when you have 2 people. So that's part of what the self-funding will go ahead and help. I urge you to support Senate Bill 360 and authorize a notary public fund to fund for these reasons. This bill's good for me as a real estate broker. It's good for the real estate industry. I believe it's good for the other industries that use notarization. And it's good for Maryland's 90,000 notaries, the public, and the Office of the Secretary of State. Thank you very much for your time and your consideration. Much appreciated.
Excellent. Thank you very much. Next, we have Ms. Lehman. You're up next.
Good afternoon, Mr. Chairman and members of the committee. For the record, my name is Mindy Lehman. I'm the Senior Vice President of Government Relations for the Maryland Bankers Association, and I'm pleased to be here today in support of Senator Rosenpep's Senate Bill 360 on notary and setting up a notary public fund. We were also a part of the work groups that the previous bill sponsor mentioned in 2018 and 2019. Of course, you on the committee are very familiar with Maryland banks. We have 1,400 bank branches across the state, and we serve about 6 million customers. Among the bank services that Maryland banks offer, notary services to customers are one of those things. We very strongly support this bill, which we think is important, and provided dedicated funding to support Maryland notaries within the Office of the Secretary of State. I won't repeat the very good testimony that came before me. You have a copy of our written testimony, and I'll just add a very strong me too to the support of this bill. Thank you.
Excellent. Thank you very much, Ms. Lehman. Always good to see you. We now have Tobias Musser.
Thank you, Mr. Chairman and Vice Chairman and members of the Senate Proceedings Committee. For the record, my name is Tobias Musser. I'm the Chief Executive of Managed Network Service Group, or M&S Group, a Maryland company that supports just shy of 400 locations on 6 continents. I was a member of the notary work groups that we've already mentioned in 2018 and 2019, and I urge the committee to vote in favor of Senate Bill 360. As you have heard, this fund is critical to the completion of the work. There's very few people doing a lot of work, and if you could imagine both people calling out sick on one day, it certainly would cause a backlog. The work groups worked very hard to offer recommendations on modernization, and I think we all have what's best for Maryland at heart. I want to point out that the enhancements in the law that are now in effect, they need effective administration, regulation, and enforcement. And having the office a bit more robust with access to a dedicated fund really helps technology support, certification, and compliance that's needed by our state and federal contractors as they complete assessments that you may have heard of, such as NIST 800-171 compliance, ISO 2700 compliance, SOC 2 audits, CMMC. These are all requirements that various federal and state contractors have to go through that may benefit from attestation and certainly could use some bolstered support, some better scaffolding. 90,000 notary publics and 2 notary officers. I think that's the number I'd like you to hold in your head. This bill, it's not without precedence. Just by way of example, the Charities group has a special fund that's used specifically for enforcement to protect the public from scam artists who would prey on unsuspecting donors and are in violation of Maryland Solicitations Act. So with these few extra data points, I would just urge you to support Senate Bill 360 to authorize a notary public fund. The bill's good for myself. It's good for my company and others like it in Maryland that are in the compliance business. And Maryland's 90,000 notaries, the public and the office of the Secretary of State. So I thank you very much for your time and consideration.
Excellent. Thank you, Mr. Musser. And next and finally, we have Ms. Conley.
Good afternoon. Thank you, Mr. Chairman, Vice Chairman, and Judicial Committee. I'm not going to reiterate. I also was on the notary work group in 2018 and 19. But in my prior life, I was the executive director of the Maryland Real Estate Commission. And I started with the Maryland Real Estate Commission when special funding went into effect. So I'd like to give you firsthand knowledge about how special funds changed the antiquated and dysfunctional operation of the commission. Prior to the enactment in 2007, the commission had over 57,000 licenses that were issued with extreme delays, no follow-up, due to lack of staff, and labor-intensive manual work needed to complete the applications. Most importantly, though, there was 3,000 consumer complaints that were backlogged because they only had one investigator to investigate those complaints. So the special funds allowed us to use the revenue generated by the licensees to bring our database first off to the 21st century. And also with those funds, we were able to automate our licensing system. We hired investigators and paralegals to address the backlog and eliminate the backlog within a year and a half. And new complaints were then being addressed within 30 days of receipt. We also bolstered the licensing staff. We put the complaint system in for consumers online. We instituted continuing education for brokers and managers. We also automated systems so that licensees got their renewals online, could renew online. And to be honest with you, during this pandemic, agents were able to transfer from one broker to another, renew their licenses, upload their continuing education, all without a hitch because everything was online. Okay, the anticipated, these were the things that we were able to do with special funds. Now, the anticipated revenue for the notary special fund of $200,000 is obviously a fraction of the amount of money that the Real Estate Commission had, but the point is the same. The special funds will provide the notary division the resources and flexibility to meet customer needs and demands and the requirements of Chapter 407. So I urge you to support Senate Bill 360 and authorize the notary public funds. It will be needed and it will be beneficial to all the notaries and to the public because they will have access to information at least a little bit more instantly than they can at this point. So thank you for your time and consideration.
Excellent. Thank you, Ms. Conley. And with that, that'll wrap up Senator Rosapep's panel and the testimony for Senate Bill 360. We'll turn to the committee for questions. Seeing none. Thank you, Senator Rosapep, and thank you to your panel. That concludes the hearing for Senate Bill 360. We'll now move on to Senator McCray with Senate Bill 363. Senator McCray, you are up.
Thank you, Mr. Chair. Thank you, Mr. Vice Chair. Thank you, members of the committee. I come to you in reference to Senate Bill 363, court improperly summoning a police officer's civil liability. This bill was heard before your committee last year, so it's not new to many of you all. This bill was just not voted on in your respective committee. I'm assuming because of Corona. COVID-19, it may not be. But once again, Mr. Chair, this bill simply gives the right to create a civil rights of action for damages against a person who knowingly and with specified intent called the police with another. So they're falsely calling police officers on folks with the attention from a harassment or things of that nature. We've seen this across the country. We've seen this in a number of situations more recently. One in New York in the park where the gentleman was just bird watching And gentleman, Mr. Cooper was just bird watching, Christian Cooper, but Amy Cooper decided that she wanted to call the police not once, but also twice to say that Mr. Cooper was actually assaulting her in that respects. While this is a crime to falsely call the police, we wanted to make sure that if that the person that had the police falsely called on them, that they would be able to seek civil remedies from this standpoint. Today, I'm not only by myself, but I'm also joined by Mr. Willie Flowers, who's the NAACP state president, Kendall Wade, and Joe St. George, who also joined me on the panel last year. Mr. Chair, I not only ask for a favorable vote on this, but I hope that it do come up for a vote on this important issue, just in reference to the state of Maryland. Thank you, Mr. Chair.
Excellent. Thank you, Senator McCray. And you're correct. We just ran out of time, ran out of runway last year with the pandemic. I remember this bill. So with that, we'll turn to your primary witness, which is Ms. St. George. You're there. And since you were the primary, you will have 5 minutes. So Ms. St. George, you are up.
Am I on? Can you see me? I'm sorry, I'm not good at this Zoom stuff.
We can hear you and we can see your picture. We can't see the live shot, but.
Oh, okay, hold on.
There you go.
All right, sorry. Hey, guys. So Chair, Vice Chair, entire Judiciary Proceeding Committee, thank you for giving me this opportunity to come before you once again. Since the last time I was before you, so many sudden things in our country has occurred. Of course, we know about COVID-19. But the greatest thing that has happened that we're seeing is that democracy is under siege, and that there's a great controversy between truth and lies. And that no matter what we focus on, at the end of the day, we know that you as a legislator have a specific job to do, and that's to hold people accountable and to hold people to the truth. Freedom does not mean we can do anything we want without care to the outcome of our choices. Freedom of choice is both a great privilege and an erroneous response and an enormous responsibility. At the heart of SB 363 is the key of focusing on holding people accountable for the wrongful summoning of police based on discriminatory perceptions or skin color bias. Every citizen has the choice to call the police when there is a reasonably perceived threat of danger. However, when a perceived threat is not reasonable and it lacks any credibility, those individuals who choose to still call the police, particularly on people of color, who have not done anything to be threatening or cause any harm to anyone, those choices must have consequences. And SB 363 provides the remedy to individuals who have the police wrongly called on them. We saw the siege on the Capitol, and regretfully, we have individuals in this country that believe that there shouldn't be consequences for their choices. And I'm just going to point to one story. I think you can read the rest of my testimony, but there's a story about Jenna Ryan, who participated on the siege to the Capitol. And she says that she believes that she should be pardoned because she attacked the Capitol based on the directive of the president. Now, should she be pardoned, or should she be held to accountability as an adult who can reasonably perceive between right and wrong? And what I'm asking of you today is to focus on what this bill does. It gives a right of redress, and we're not creating any new liability. Why is that? Because we already have civil liability in situations of defamation. This is pretty much more of a defamation type of civil claim than it is anything else. Why? Because of course we know defamation is all about lies. And that's what this bill covers, is wrongfully misrepresenting the truth, but in this situation to the police. And we know in defamation cases, all you need is an oral statement that's false, that causes harm. Our Supreme Court has made it clear that in defamation cases, an individual should receive compensation. In this situation, this person makes a material misrepresentation or representation, even if it's reasonably believed. But in this situation, the burden is on the plaintiff to establish that it was unreasonable for a person to believe that someone was engaging in some type of criminal behavior that required the police to be called. And so just as in a defamation case, the plaintiff should have the right to present the evidence before a court and a jury so a jury can make a decision. The difference between a regular defamation case and this one is that you have the police involved. The individual goes as far as to call the police to engage in their behavior of harassment, of causing harm to a third party based on an erroneous belief. So I want us to fully understand we're not creating new law. We're going to use time and true standards of review, timed and true standards of evidence that's required by every plaintiff to bring any civil claim. And we just ask that in this situation, though, that you as a legislator send a message to Maryland residents that when they choose to use public funds and public resources in an unreasonable manner to harass, annoy, or to cause harm to individuals who don't need the police called upon them, that there's a price to pay. When people understand there's a price, they will think twice and take the necessary steps to investigate the facts of a situation before they engage in calling the police. Now, let's make clear, we're not talking about situations that are true emergencies. The facts will bear out before any jury or to a reasonable person if the facts are legitimately demonstrating that the person should be afraid of themselves, afraid of harm. So I just wanted to, in closing, make sure that we understand there's no new standard of review and that we're just looking for accountability. Thank you very much.
Excellent. Thank you, Ms. St. George. And I neglected to mention this at the top, but as the witnesses come up to when it's their chance, just make sure you identify yourself, your name and the organization that you're with, or if you're representing yourself, just.
And that's right. Joe St. George with the Women of Color for Equal Justice.
Excellent. Thank you. That's my fault. Charge it to me. All right. Thank you. Good to see you. Next, we will have Mr. Wade. I think Mr. Wade is here.
Good afternoon. I'm here.
You're up next. Good to see you.
Likewise, Senator. Thank you so much and happy belated birthday. I want to thank you all again for having me here, Senator McCray, Delegate, Nick Charles, and also my other colleague who just testified before me. I'm Kendall Wade. I'm a former candidate for Sheriff of Prince George's County. I am a veteran of law enforcement. I'm a frontline worker, published author on leadership, organizational leadership. And I'm here today to testify for this bill. As you all know, law enforcement has been under a different light as of lately. There are some things that have been brought to light that we have to shed light on, and there are some things that we are continuing to have unfold. But one of the things that play a part in some of the interactions between law enforcement and the community are unnecessary calls of service. One, law enforcement is stretched entirely too thin. We already have limited resources, from manpower to equipment and things of that nature, that we are already combating. So to add the unnecessary calls where people are knowingly using law enforcement against the original purpose of it for their own personal gain, to either have people removed or to have things done that's not within our bandwidth. People, if you look at the calls of service as a whole, especially in Prince George's County and larger metropolitan areas such as Baltimore City, calls come in all the time for a range of things. It's important that we make sure we narrow that focus so that we cut down on the interactions, especially because of COVID. You have other things that will cause friction unnecessarily. So let us continue to, while we look over the issues that law enforcement is currently having, and while we work to fix those things so we can better serve the community, let us cut down on unnecessary calls of service that cause harm, that exacerbate issues in the community, and all in all, that further erodes the trust in the community trust, the public trust. And that's something that we're working to ascertain again. And with that, I yield. I don't know how much more time I have, but I'll yield my time for questions.
Excellent. Thank you, Mr. Wade. Good to see you again. We'll take questions at the end of the entire panel. So with that, we'll move on to Mr. Flowers. Are you here?
Yes, good afternoon. Good afternoon, Mr. Chairman. My name is Willie Flowers, and I'm with the NAACP Maryland State Conference. I'm here to offer a favor report on Senate Bill 363. The intent of the bill is to mitigate false 911 calls that are triggered by overzealous callers who, in most cases, are based on racial fear. These calls create friction in communities and also have the effect of heaping false charges on residents who are just trying to live. The calls are an unnecessary use of time by police, security, and other law enforcement agencies. There are many examples of this, but recent national false calls have shown how white people knowingly weaponize the police and profile African Americans. We know that because many of the callers emphasize race. We know that from the New York City Central Park situation. This triggers concerns about the history of race-based profiling that are at the center of much of the racial conflict that we see because they are all based on lies. The story of Emmett Till is an example, where a young man's life was taken by lies, and there are countless other cases that showcase racial stereotyping, a fear being at the center of all of the false calls, with no retribution or education to the person who triggered the call. As recently as November of last year, a false 911 call was made at a polling place on an early voting day. The fragile caller was upset about a question about the support of a candidate, not a dispute, but a conversation. No physical altercation, but a conversation. This led to another conversation. No physical altercation, but a conversation that caused the fragile caller to call the police, get a peace order, file criminal charges, and the caller did not show up for the peace order and our hearing, and the charges were eventually dropped. The caller, while fragile, admitted to going overboard, but the damage was done. Although the charges were dropped, the accused person has had to deal with attorney's fees for defense, concerns about reputation, unnecessary stress, the time-consuming practice of court and record expungement. I know about these details because I was the targeted person on the receiving end of this call. The only thing that I would add would be automatic expungement for the person accused of the lie and for them to be reimbursed for their time and money. There should also be a larger level of concern about the role of the community policing to mitigate these crisis situations that should never happen. For now, Senate Bill 363 is a step in the right direction to reduce these types of incidents and will be helpful for the community and the police. Thank you.
Thank you, Mr. Flowers. And with that, we have Mr. Muhammad. You are up next. There you are.
Thank you, Mr. Chairman and Senate Judicial Proceeding Committee members. My name is Uzaifa Muhammad. I'm the Government Affairs Intern for the CARE Office in Maryland. On behalf of the Council on American Islamic Relations, I want to thank you for this opportunity to testify in support of Senate Bill 363, improperly summoning a police officer. The Council on American Islamic Relations is America's largest Muslim civil rights and advocacy organization. Over the course of especially the last year, there have been many issues on the forefront of our society. Among them is increasingly excessive police interference with daily life. Police are called too often, especially on people of color, for non-emergency situations which can escalate rapidly. Maryland's Muslim communities are comprised of very diverse ethnic and racial groups, and many individuals have also had their race or religion weaponized by others who seek to do them harm. Oftentimes, as we have seen in numerous national high-profile incidents recently, racial and religious bias are the impetus for these calls. These unnecessary 911 calls not only waste government resources and divert police officers' attention from legitimately urgent disputes and crimes that warrant their intervention, but they also increase the risk of a hostile situation which can endanger innocent lives. We support this bill because it sets the tone for accountability, and we believe it will help discourage this behavior in the future, and therefore we respectfully urge your vote in favor of it. Thank you for your consideration.
All right, thank you, Mr. Muhammad. Next, I know we have State's Attorney Brave Boy signed up, but she's not here. So we will now move on to the opposition panel. Mr. McAvoy, you are up. We're going to get you in the screen one of these days.
Here we go.
There you go.
I have to go sideways. All right. Thank you so much. Thank you so much, committee. I'm trusting you can hear me. Got new headsets on. I want to testify in opposition to this bill. As I'm looking through it, what I'm seeing, panel, is I'm seeing, as was admitted by the first person testifying, this is a duplicitous bill. And we've just got to stop entertaining bills that are actually coming at this from the perspective of we already have something and we want it to be agendized to something that we're doing. The New York issue was mentioned. I've got a lot of out of work actors. I think that we need to be conscious of something that Senator Cassidy said the other week, was that we should be concerned with things that are happening in our state, not things that are fomented on social media, which may be actors and actresses. But to the legalities of the issue, this is simply too broad in scope. And it actually has as its premise that the person calling is aware that we have a Maryland Declaration of Rights. A lot of Marylanders sadly are not, and actually knows anything about the Constitution, for instance, that has a preamble. And we just can't expect that of our people. What we expect is to have safe communities. Police help entertain that with safe communities and initiate that. And we mustn't leave it to someone who is in fear or has a rightful cause of action to weigh out the intricacies and legalities of what their actual legal concern is. If they're calling for a non-legal concern, well, unfortunately, we have a case that relies on police to mitigate these issues. And I reject the notion, I live in Baltimore City, okay? I reject the notion that every time a police officer is called, somebody's life is in danger. It's just not the case. Okay, so we need to stop gaslighting these situations. We already have defamation suits. We already have cause of action for wrongful police reports, and those should be exercised. And I wish more of them actually went through the court. We know the courts are busy, and so they don't. But the idea of putting civil action to this when people can't possibly, I wish they could, have the civic order to actually know what our laws are, it's just not a fact. So again, urgent unfavorable, and let's focus on things that are affecting our state. Thank you so much for your time, committee.
Excellent. Thank you, Mr. McAvoy. And with that, that'll conclude the testimony from the panel. And now we'll move to the committee for questions. I saw Senator Sidnor first, then we'll go to Senator West. So Senator Sidnor, you're up.
Thank you, Mr. Chair. I had a question for Mr. Flowers. The incident that you testified before this committee, did it happen in New York?
No, it happened right here in Howard County, Maryland.
It had happened in Maryland. Oh, okay. I just wanted to be clear for the record that this bill does affect Maryland citizens. Thank you.
Excellent. Thank you, Senator Sidnor, Senator West, and then Senator Lee.
Thank you, Mr. Chair. I've got a question really for my good friend, Senator McCray. I think we may have had the same conversation last year. So let me give you two examples. One comes out of the testimony of the Women's Law Center, where they say, imagine a neighbor hearing what sounds like someone being abused in the apartment next door. The neighbor calls the police. Perhaps the victim decides not to implicate the abuser and does not pursue either a civil protective order or criminal charges against their abuser. The abuser might then seek to sue the neighbor for damages. And then I've got a separate hypothetical, which occurs not terribly infrequently in my district. Sometimes there are organized burglaries going on in a neighborhood. And so there'll be a neighborhood meeting and I'll attend the meeting and the neighbors all come and the policeman stands there and explains what's going on and what they're trying to do about it. And then concludes his conversation with a statement, you know, if you see something suspicious, call us. We're there to help you. We know how to investigate. give us a call so that we can come and check it out. So you, in response to that, you might have an elderly widow who sits at home, and she sees out the window some person who doesn't look like he lives in the neighborhood, looking suspicious, acting a little suspicious, paying very close attention maybe to people's windows, going up their driveways and taking a look around, and she calls the police. So in both of these hypotheticals, the question arises, is there a duty to investigate before you call the police? Or if you call the police to report something suspicious, whether it's the neighbor next door or somebody out on the street who looks suspicious, are you running the risk of being sued in a civil lawsuit under this bill?
You know what, Senator West, this is the challenge of when we have bills and the bills aren't voted on. This is absolutely deja vu. This is the same conversation.
I thought so.
And it was Ms. St. George who spent probably 10 minutes back and forth with you on the same analogy. But I'll go back into what was stated last year. There's a piece in there where it says knowingly, and knowingly, the two situations that you stated, they aren't knowingly. So let me explain what knowingly example is. The Central Park case was referenced a number of times. You have a gentleman, Mr. Cooper, who's just bird watching by himself in the park, a public park, may I add. And you have Mrs. Cooper, no relation at all, who has her dog. He asks, hey, can you put the dog on a leash? Mrs. Cooper then becomes irate, and the first thing she does is she weaponizes and calls the police and say that a black man's harassing. The second call says that the black man's assaulting, and we know what that intention was. This is caught on camera, and it elevated to a national story. While it was mentioned in reference to a Maryland case, and I'm thankful that President Flowers talked about his situation in Howard, this is not something that's unique across the country. The challenges is that these are national stories that are now coming, and folks that weren't sensitive to the issue are now being educated to things that happen in neighborhoods all the time from that standpoint. So to go back to your question, the two incidents that you stated aren't, but there are incidents where folks knowingly call the police on it, and that's wrong. And we want to make sure that there is a civil opportunity for folks to remedy that when that does happen to them. I'm sure that Ms. St. George wants to jump in with this. Like I said, it was you and her that had 10 minutes of dialogue last time this bill was heard.
Well, I guess my number one question is, I can't see it in the bill. Is there an implied duty to investigate before calling the police? Or can you see something suspicious or hear something suspicious and call the police without conducting any sort of an investigation, and in doing so, not run afoul of this bill and be subject to a civil lawsuit?
So I'm going to go to the first page, line 19, where it says a person may bring a civil right of action for damages against another person who knowingly causes a police officer to arrive at a location.
Okay, so what you're saying is if you don't know what's going on, you just hear or see something suspicious, you are not endangering yourself by calling the police.
I 100% agree. That was not an intentional act of calling the police for a malicious reason.
Okay, thank you.
Thank you, Senator West. So now we'll go to Senator Bailey and then Senator Castley. Oh, sorry. You know what? Sorry, Senator Bailey, hold tight. Senator Lee was next. My apologies.
Yeah. Thank you, Mr. Chairman. I do believe that this happens, and I think some of the recent cases that not only were in our state but also in other states, where an individual has used their obviously power of and unfortunately motivate sometimes by racism to harass or just have superiority and control over someone else's life. And unless you're in their shoes, it happens sometimes, people of color, unless you're in their shoes, you don't know what it really feels like. Okay. But and also the cost of having to defend yourself, get counsel, spend a lot of money, not to mention your reputation, everybody looking at you like you're strange or you're dangerous. In this, and anybody can answer this, Ms. St. George or Senator McCary, don't you, if you're a plaintiff, you have to prove that the defendant intended to do this, right? Intended to infringe on your life, your rights, intended to discriminate, right? It's not like just some willy-nilly lawsuit. Is that correct? Maybe you all can elaborate on that.
I believe that you have it in the right manner. I want to make sure that Ms. St. George does get in here too, because she does have a hand up too, Mr. Chair, so.
I think you just muted yourself again. Go ahead one more time, Ms. St. George. Just click unmute. There you go.
Thank you for giving me the opportunity to weigh in. I want to make sure that we all understand. My background, I'm a 26-year lawyer. I've been a trial lawyer, not in particularly in civil litigation, representing Fortune 1s and 10 companies in major wrongful death cases to medical malpractice defense. And so I defend corporations. I've always been on the defense side. And in this situation, I can speak from the defense perspective of what are the facts that I would need to defend myself if a claim is made. In this situation, Senator West, I would have an investigator identify the noise that came from the room. There would be more than one person who can testify that there was noise or some type of noise that caused that person to have a reasonable belief that someone was being harmed in that house. I think the Breonna Taylor case was an example of a case of whether or not someone heard the police say that they were executing a warrant, and they had 14 people testify that they didn't hear it. So the credibility of someone's testimony is always going to be weighed against in favor based on corroborating evidence, unless there's a smoking gun and the person says, I'm calling the police and this is using the N-word and I hate this person. Those are rare situations. The situations that we will always find people of color and other marginalized people in is when there are circumstances that lead us to the direction of this being discriminatory. And in the collective, the circumstantial evidence leads us to that. But as a good defense attorney, I know how, in any plaintiff or defendant who is in this situation, their good defense attorney will look for that evidence that supports their claim that their belief was reasonable. And I think that just as defendants in criminal cases of the wrongful, someone shooting someone has to mount a defense, the plaintiffs in those situations, because you have the dead person, don't have to prove the damage. All we're saying in this situation is allow there to be a claim that a jury who's given adequate information and data around the facts to make an informed choice about whether or not the acts and the conduct of an individual called the police was discriminatory and a waste of police resources.
Thank you, Ms. St. George. All right, so now we'll go to Senator Bailey, you're up, and then Senator Castley.
Okay, thank you very much, Mr. Chairman. Senator McCray, I guess this might be best answered by you, but as you're aware, I was a policeman for years, and after 9/11, one of the biggest issues that affected police was trying to figure a way to get the community involved and engaged. And in doing so, they came out with a slogan, and it didn't start in Maryland, but it was definitely used here considerably: see something, say something, right? And it came out and it tried to get everybody engaged. Now, where I come from, we have numerous Homeland Security targets. We have bridges, we have the nuclear power plant, we have different situations. People might go and just fish next to them, whatever, but members of the community would definitely call and say, by the way, there are people here, we don't know what they're doing, the whole scenario. And I guess what I was trying to make sure of is if these people were in one of these areas and they were, let's say they were white or they were people of color. Just by the fact that somebody called on them and the police went and engaged them, does this in fact play into the fact that this would give a role that they could be the person that called, have a civil suit filed against them for doing something that we have asked them to do for years. And there was no race-based association with this when we came up with the fact of trying to identify the Homeland Security targets and work forward.
I think that the exact situation, I'm not sure if you did that specifically to frame it that way, but that's not knowingly calling someone because of a race-based situation. But let me give you another one, just so that you're clear, just a reference to an example. 3 young Black teenagers are just sitting in the park and they're not doing anything type of malicious, and the person says, hey, that looks out of place. Well, why would they be calling, or they have a gun, or they have this? That's knowingly doing something that they did not explicitly want to do something for those folks. So the example that you gave, Senator Bailey, I don't believe that that's the case. There are a number of occasions where folks just call because they're sitting in a public place, they're doing something maybe with their friends, and a person has a malicious motive in reference to calling the police for those actions.
Thank you for that clarification. So my second question would be, in law enforcement, clearly, if they made an allegation that those gentlemen had a gun, something of that degree, using your statement, we automatically have a false report to a police officer, which is a criminal arrestable offense. And so my question is, in these instances that you're talking about, one of your panel members talked about, was that addressed accordingly by the police as a false report? So in the situations you'll see, it's a number of times. I gave the New York situation, which was a real situation. So I'm not going to talk about these hypothetical examples. You saw where Ms. Cooper was prosecuted. We're not looking for the criminal charges. This is a civil bill to be able to make sure that there's some form of monetary response in reference to this action being filed against someone maliciously. I don't disagree with that. What I was trying to figure out is the fact that Maryland, where we do have a false report to police, not dealing with it globally, dealing with what we have right here. I was just wondering, how many times has this been addressed by the police so that we could find out how many issues are actually occurring here?
I will have to get back to you with that information, Senator Bailey. I'm not sure of how many false police claims have been made from Maryland, but we both have access to that form of information. I don't mind. If you want to, or I can reach out to the library and figure out how many false claims have been filed where police have been called.
Okay, thank you.
All right, Senator Bailey, thank you. All right, now Senator Castle, you're up. I see that. So look, typically for the witnesses, if the senator makes the inquiry, then we'll call on you. But I just want to make sure that sorry about that. All right, Senator Castle, you're up.
Thank you, Mr. Chairman. So I get questions for Senator McCray, the sponsor, and kind of tagging in with what some of the previous colleagues had brought in. Why is this not see something, shut up? I mean, we went from see something, say something, and I don't see why this is not saying, if you see something, shut up. It was proposed that, well, you should before you call the police, you should have reasonably perceived that you're in danger, which is like, well, I can't call the cops unless I have probable cause to make an arrest. So, do you fear that maybe this would have the other, as it be considered, this would be, you know, you're saying, well, we've got people calling who shouldn't, but isn't it just, have you considered the possibility that a law like this would discourage people who should have called? I mean, somebody pointed out, that's the whole lesson of 9/11. I think Senator Bailey pointed out, was that don't be afraid to call. Let the cops go in. The worst that happens is the person gets a greeting from a police officer. He says, hey, how are you doing? And hopefully the 911 screener says, what's the person doing? Oh, he's just sitting there being a black man. Okay, but what's he doing? Oh, he's being a black man in my park. Hopefully that would elicit a 911 response, or perhaps some foul language from the 911 operator to the caller. But And then of course, if they said, well, he has a gun, but he doesn't, well, that's a criminal prosecution, right? For both perjury and for false, a false statement to the police officer. So don't we have to consider that this may cause folks to shut up who we really would rather they didn't?
No, explicitly, Senator Cassidy, I don't think that it goes in that direction. I think that it goes to the direction of those folks that are falsely called knowingly for the police. Our President Flowers gave a clear example of a situation that happened in the state of Maryland where folks are using these race-based opportunities to weaponize our police department to come out and address issues that are malicious and hurtful to individuals. This may not be something that you see every day, but this is very frequent in primarily African-American communities or communities where folks may feel like minorities don't belong in, someplace that are public where everyone belongs, but they may feel like that person does not belong for whatever reason they do, and they do something malicious. They go out there and they don't just say that a person has a gun. Explicitly in the Central Park, the lady stated that he assaulted her. That a person that was watching birds, that all he did was ask for her to put her dog on a leash. And what she did was she weaponized the police to come out there and was caught red-handed. Mm-hmm. And just happening in Central Park. We had Barbecue Becky. We had the Oakland situation. We had the St. Louis situation. And as President Flower, it happens right here in Maryland on a daily basis. The reason why, Senator Cassidy, folks are just recognizing because it's rising to a national occasion where people are seeing this happening. And what happens is folks that don't traditionally have this happen to them, that are in probably white communities that don't see it every day, now are educating themselves and say, no, this is really happening to my neighbors, to my friends, to my families, to my coworkers. And now they're becoming sympathetic to put forward and address this issue.
So here's a challenge I have is that, and I noticed, Senator Lee said, well, hey, you would have to prove all these things. They would be very difficult to prove unless it was true. But that's completely irrelevant because the damage will be done if I'm an obnoxious person and my nosy neighbor calls the police because they thought they heard my wife screaming, they thought I was beating her, and they call the police and they come to my house, I'm just going to sue her. I'm going to sue her for everything I can under this. And now she's going to have to come out and attend deposition. I'm going to jerk her around because I'm that kind of person who just wants to jerk her around. And she's going to have to get her, she's going to have to pay for a lawyer to defend her. She's going to have to put all that time in. She's lost. She's lost from the minute I filed the suit. I don't care if I win. I'm just going to try to jerk her around. And so what you end up with is that we're going to be empowering people who are just angered that their neighbor called the police for anything. And I don't hear there's no real solution to that. So we have to weigh between, I think we on this committee have to weigh between what's the worst problem here? Is it that we've now turned see something, say something into see something, shut up? Or that maybe there's a chance that these problems are so severe, which we haven't heard anything until now in Maryland, that they're so severe that it's so common and so pervasive that it's just got to be addressed by this kind of litigation because nobody is, the police, for whatever reason, and the prosecutors have no interest in charging people with false statements or with accessory to a false arrest or perjury, that apparently none of these are dissuading these people who are just bound and determined to malign totally innocent people who they don't even know. So these are some difficult stuff for us to weigh. I look forward to the committee discussion on this, but I by no means see this as just a one-sided issue. This is very complicated. Thank you.
Thank you. Mr. Chair, just respectfully, if you can give me a second. I think that while the senator acknowledged that he didn't feel as though it's a problem. So while it's not a problem to the respective senator, it is a problem across the state. It is a problem across our jurisdictions. It is a problem locally. And while you try to minimize this issue to where it doesn't hurt our families, our communities, when folks go through this situation, the bill would not be brought forth. It wouldn't be people such as President Flowers, Miss St. George, or Kendall Wade that are trying their best to address this issue. So while it might not be a problem in your respective area, we are one Maryland, and it is a problem for a lot of our Marylanders. But
you're misstating what I said.
I gave you time to talk, so let me have
okay.
Time.
Go ahead.
So we cannot minimize things that we see that happen right there in front of us, because you're talking about one specific community. We've brought a number of folks because we're a very diverse Maryland, and you have to recognize that. President recognized that this is happening in Howard. This is happening in Baltimore City. Kendall Wade is from Prince George's County. So we have to make sure that we put that forward and not minimize or not take say that this issue is way more important than this issue, because that is not right, and that is not one Maryland. Mr. Chair, I would also like to recognize that there are folks that have, while it's been said a couple times that this isn't happening in Maryland, the good president from the NAACP has had his hand up for a significant amount of time to this issue from a personal standpoint. And I think that that should also be recognized. And from a trial attorney, I'm no lawyer, so I'm in here with a bunch of lawyers. You have Ms. St. George that can put that space of the argument. And I just want to recognize that their hand has been up for a significant amount of time. And then when Senator Bailey was addressing it from a police issue, you have police, you have public safety right here with Mr. Wade. And I just also wanted to lift that up too. So while the questions are being directed to me, I think that we have a diverse panel, and that's why we bring forward panels to speak to the subject matter expertise with a public safety officer, a lawyer, and someone that is not only representing the NAACP from a state conference, not a local jurisdiction, but across the state. So thank you.
And I just want to respond briefly to Senator McCray, because you totally misstated what I said.
Senator Cassidy, I'll let you get in real quick.
And in essence, accused me of being an insensitive bigot and a racist. It's kind of what his testimony was, because what he's suggesting that I sort of live in some idyllic little community that doesn't see the bigger picture. What I was saying is there's multiple considerations here, because just as much as your bill is pushing one side, we also have the issue that see something, say something does save lives. And we can pull out thousands and thousands of instances across this country where people seeing something and saying something that was very minor ended up saving lives, finding the child who was abducted, preventing the bombing, on and on and on and on. And so what I've suggested is that there's two issues here, and they're in balance. You're saying we need to be more restrictive on people reporting, and I'm saying yes, but that's going to come at a cost, because you can't push this without balancing that. And that's the challenge we have. And this isn't a matter of us calling each other racist or saying each of us is insensitive to the other. That's not the issue. There's valid concerns on both sides, and you're not going to get out of passing a bill like this without impacting both sides of this, right? And so that's all I'm saying. And so, you know, to sort of the suggestion that I'm sort of being insensitive to these issues. No, I followed the national stories. I heard the reports. They're horrible. But you know what else is horrible? When somebody could have made a phone call and saved a child who was being abducted or who had been abducted, or a woman who was being violently abused, or a bank robbery that was about to go down, things like that. Those are also horrible things. And this committee has a challenge of trying to balance these issues and come out with something and whatever we do isn't going to be because we're racially insensitive. It'll be because we have to see all the issues and not just a piece of it. Thank you, Mr. Chairman.
Thank you. All right, so typically try not to exercise the mute button too often, because it doesn't get this unriled, but just restoring some balance here. So Senator McCray, so typically the way it works here is that the senator will address a question to an individual panelist. You as the sponsor and as the director of your panel, typically you can say, hey, look, I'd like Mr. Flowers, Ms. St. George, Mr. Wade. So at your leave and in deference to you, I'm going to open it up, and please direct us to whoever you think on your panel would like to speak and address some of the issues that are responsive to Senator Cassidy or anyone else in the committee that have raised during this testimony. So over to you, Senator McCray.
Thank you, Mr. Chair. Before I weigh in and direct, I just want to make sure that I comment back on that. The senator said that I said that he was racist. That's his interpretation. I think that he did quite frankly say that it wasn't a problem. And that's not true. It is a problem. There are folks that are, this bill would not be here if it wasn't folks that needed this to be addressed. The second thing is that the good senator minimized the issue to make it seem like it was non-existent. And I just want to lift that up. While I debated this senator just this morning and on Fox 45, one thing that I know that I'm clear, I've never stated that the gentleman was a racist. I was just stating clearly what I saw and what he was explicitly stating in reference to minimizing the issue and saying that it wasn't a problem. I just want to start with Kendall Wade, because when Jack Bailey asked the question, Senator Bailey asked the question from a public safety standpoint, I think that he is best the subject.
Wade. Thank you so much.
Senator Bailey, I want to say thank you for your service. When it comes to the matter of national security and this whole see something, say something, say something served a very specific purpose. That does not in any way is affected by what we're saying, because what we're saying is basically, we talk about 9/11, but what about January 6th when the intel was there? When people did see something, they did say something. And that result was people storming our U.S. Capitol. And so let's talk about why that was allowed to happen. That was allowed to happen because their color was different than mine. And I'm just going to be honest. And sometimes we don't want to have that tough conversation, Senator, but it's a fact. If the intel that was had and the things that were said and was seen were that of a group, a minority group of Black and brown people, it would not have gotten that far. And so what we're saying is we don't want people to weaponize law enforcement for their particular preference because they see something they don't like. See something that you're concerned about is one thing, but seeing something that you don't like is another. And all we're saying is, hey, let's cut that out. And yes, there are a lot of cases, specifically in the area of domestic violence was a division that I served in for a long time. And people will go and apply for restraining orders and protective orders. They will go to court, they will go to the commissioner and take an oath to not purge themselves, and they will lie about the evidence. And after they go to court, the judge will throw it out because there was no standing. Nothing happens. But the person who was suspended from work or could not return to work because they had a restraining order against them, they just suffer. They just suffer. And there are things. And thank you so much. And I just want to say one last thing. That if some of you all feel as though it's not a problem and it doesn't affect certain communities, what do you have to lose by passing it? Because clearly it won't affect the community that you're in.
Thank you, Mr. Wade. And Mr. Chair, only because it was referenced a number of times that this isn't a problem, I'm going to close with and ask President Flowers to step in. And I apologize, Ms. St. George, this is belabored for an extensive amount of time, and I don't want to have the committee feel a certain way, but I think getting President Flowers, who actually personally experienced this, should be able to weigh in here.
Absolutely.
I just wanted to address the notion that the item that the senator listed that would happen happened to me. I had to appear for a hearing because this person decided to do that. He knew the law, so I appeared for a hearing. He did not show up. He called the judge and said he wanted to reschedule it. I was charged for a misdemeanor, Class B misdemeanor. I had to prepare myself to go to court. And quite frankly, I was prepared to go to court. So all that happened. I'm dealing with a situation now that I'm having my record expunged. So all the things that you listed happened to me out of basically some fragility of a man who was in some way felt uneasy about a conversation that was unnecessary. I didn't threaten him verbally. I didn't offer a backside of a foot or any of that. It was a conversation, and he was in whatever way had a fragile disposition, and his only recourse was to call the police. Now, let me also add that in Howard County, because of what I do at the grassroots level, there was a case of a young lady who called and did a false police report because she created a story about her being accused of stealing from a CVS. And the police was involved with this in her story, but none of the story was true. A week or a month or so after this happened, the Howard County Police did what was mentioned earlier, and they filed charges on her. But the same thing hasn't happened to this same person who made a false accusation toward me. So my point to you is that there is some subjectivity to in use of this retaliatory charge that counters a false allegation, but it's not always used. And I have never heard it used to support an African-American family or individual.
Appreciate that. Thank you, President Flowers. Senator McCray, I'll leave it to your leave. If
Ms. St. George, if it's 30 seconds a minute, I want to be respectful of the committee also.
Appreciate it. All right, Ms. St. George.
I just wanted to add, in Montgomery County, we had the police called on 3 or 4 young men at McDonald's who were just eating their food and waiting for a ride. And it made the news, and the officer used the N-word on these young men. So we had another matter in Montgomery County. The police called at Lifetime Fitness. I personally helped in addressing that case and getting the young man out of prison because he was actually experiencing a health crisis at the Lifetime Fitness. So Montgomery County has seen a lot of cases where the police is wrongfully called, and I wanted you to be aware of it. But then secondarily, I wanted to say also that with regards to the, I think Wes or Cassie's question about, do they have a duty to investigate? No, the facts will support what they see and what they say. But I would say that we do need to change the moniker on see something, say something, to see something and tell the truth and say something. Maybe we need to add that to that slogan, because people are using the see something, say something inappropriately. Just wanted to add that.
Thank you. And thank you, Mr. Chair. Thank you, committee, for your indulgence.
I appreciate it. Thank you. That first incident you mentioned happened in White Oak, about a mile north of my house. So we're well aware of that one. Okay, with that, that'll conclude the hearing and the testimony for Senate Bill 363. We'll now move on to Senate Bill 364. Senator McCray, you're up again.
Thank you, Mr. Chair. And this one I am by myself. I hope that it isn't as eventful as the last one. Senate Bill 364 basically is where civil claims against law enforcement officers of an institution of a higher education, a prohibition for non-disclosure agreements. Baltimore said this was also a bill that was heard last year because of COVID-19. It did not come up for a vote. But this basically says that when our respective jurisdictions are making payouts, that they can't make people sign non-disclosure agreements for that. You should still be able to speak your truth. What happens is in the city of Baltimore, we already did this for our police department. We did this about, I want to say, a year and a half ago, 2 years ago, Mr. Chair. And we're just looking at this for all police departments in the city of Baltimore. Many of our state agencies, all of our state agencies already operate under this respective condition. So if you are Morgan State University Police, they make a payout, you still can be able to speak your truth. University of Maryland Police, you still can speak your truth. We're just trying to make sure that all police departments operate in the city of Baltimore fall under this respective issue, where it's been decided on a local level already that this is the direction that we should move in. This bill was unanimously voted amongst our delegation, and a letter should already be with your office, Mr. Chair. Thank you all again for the opportunity, and hope that you can vote favorable for Senate Bill 364.
Excellent. Thank you very much. And if I take that up this week. Looking around the panel, seeing any questions, seeing none. Thank you very much, Senator McCray. We'll be in touch soon.
Thank you.
All right, excellent. So now we'll switch over to Senate Bill. Well, with that concludes the testimony for the Senate Bill 364. We'll now move on to Senate Bill 369. Senator Peters. Senator Peters, you are up. I see you there. There you are.
There I am. Thank you, Mr. Chair. This is one of a family of bills from the Department of Defense. And as you know, as former chair of the Veterans Caucus, we sponsor these bills. This is targeted at attacking the issue of child abuse, neglect, and domestic abuse, and allowing us to deal with that. And in order to do so, the bill requires a local Department of Social Services that has a U.S. military installation to enter in an MOU into the Military Family Advocacy Program. So this is a positive step, but in order to take these things head on, we need to have an MOU.
Got it. Excellent. So we'll move on to your panel. And for your first panelist, we have Mr. Arnold. Mr. Arnold, you're the primary panelist, so you'll have 5 minutes during your testimony. So over to you.
Roger, and thank you, Senator Peters, for the warm introduction and for your sponsorship of this important legislation. Mr. Chairman, honorable members of the committee, The Department of Defense is grateful for the opportunity to support the policies reflected in Senate Bill 369 and hopes Maryland will join the now 28 other states that have passed similar legislation on this issue. Even one child's life is worth this effort. My name is Christopher Arnold. I am the Northeast Region Liaison at the DoD State Liaison Office, operating under the direction of the Undersecretary for Defense. I am also an Army combat veteran. So Senator Smith will not hold that against you with your Navy background, but thank you for your service, sir, as well. So DoD relies on working in collaboration with state and local governments to fulfill its statutory obligation to address child abuse and neglect. The bottom line up front, particularly for those that do not know the military way of life, is that unlike civilian employers, the military services have the obligation to know what is happening with our service members and families 24/7. It is part of how we do business. Being a soldier, sailor, airman, Marine, or spaceman is not a 9-to-5 job. Information sharing between DoD and local authorities must be accomplished at the start of an investigation, not after adjudication. Federal rule establishes policy and assigns responsibilities for addressing child abuse and domestic abuse through the Family Advocacy Program, or FAP. Formal MOUs between FAP and its counterparts in the local civilian community benefit victims by improving coordination on child abuse and domestic abuse investigations. Senate Bill 369 protects victims and achieves the DoD best practice of having caseworkers ask clients if they are associated with the military, helping connect victims that are identified as military affiliated with the appropriate FAP, rehabilitative, preventative, and other services. Currently in Maryland, as I'm sure you read in my written submission, the present framework relies on individualized local MOUs to guarantee communication between the County Department of Social Services and the military community. An exhaustive review of the existing MOUs throughout the state indicate that they are inconsistent or fail to meet the requirements of federal law and policy. For example, there is no MOU in place at NSA Bethesda, and the MOU at Aberdeen Proving Ground, which Harford County offered to renegotiate following last week's House hearing on this bill, does not allow mandatory reporting to FAP personnel of child abuse or neglect cases involving soldiers and their families. DoD respectfully submits that Maryland can assist the DoD mission to protect military children and other youth from abuse and neglect by enacting the policies set forth in Senate Bill 369. Statutory authority will support development of more consistent MOUs, allow better coordination of local child welfare and military protective and rehabilitative services in support of military children and families. Mr. Chairman, DoD appreciates your recognition of the important relationship between the state and local child protective services and the associated military FAP offices in responding and providing support and services to address child abuse in military families. And we hope that you will favorably report the policy changes expressed in Senate Bill 369. Thank you.
Excellent. Thank you, Mr. Arnold. It looks like I'm outnumbered to Army, and then we've got an Air Force officer, I think, coming up here. So with that, we will move on to Ms. Eckert. Not the senator. Major Eckert.
All right, I think I'm good. Thank you. So thank you, sir. I appreciate the opportunity to support Senate Bill 0369. My name is Major Caitlin Fassett Eckert. I'm currently serving on active duty in the United States Air Force. As the Family Advocacy Officer for Joint Base Andrews Family Advocacy Program and a clinical psychologist, I'm deeply grateful for the relationship that we have with PG County CPS. Which I believe has largely been driven by the Air Force instruction requirement for a memorandum of understanding between our agencies. So working together as community partners, we're able to address the safety needs of victims of domestic abuse and child maltreatment, as well as the needs of alleged offenders, other family members, and the community at large. Although I only took over the position in October of 2020, I've been thoroughly impressed by the open communication and seamless coordination I've experienced when collaborating on cases with social workers and other professionals from PG County CPS. We here at Family Advocacy have come to wholly trust their ability to manage risk, identify treatment options, conduct thorough home visits, complete child forensic interviews, determine appropriate supervision and placement, and provide extensive safety planning services. We rely heavily on their expertise and sincerely appreciate the support and guidance they provide to our military families. Maintaining an MOU with PG County has proven invaluable in accomplishing our mission, and we look forward to continuing our strong alliance well into the future with the additional support and protection of the proposed legislation.
Excellent. Thank you, Major. Next, we'll move on to Ms. Pallett, there you are.
Hi. Good afternoon, Mr. Chairman, distinguished members of Maryland State Senate Judiciary Committee. Thank you for this opportunity to speak on the importance of coordinated community response between Family Advocacy Program and state and local child protective services. My name is Jody Pallett. I'm the Regional Counseling Advocacy Program Supervisor for Naval District Washington. Go Navy. The Naval District Washington region, there are 5 Navy family advocacy programs located within the state of Maryland. Presently, 4 of the 5 programs have established MOUs with CPS. Many are old or do not have strong enough language and need to be revisited. In my role overseeing the family advocacy program for our 5 Maryland-based installations, I'm not aware of any issues in working with CPS. However, I do foresee a benefit in having formalized requirements that come from both the Department of the Navy and the state of Maryland for establishment of MOUs between the Naval District Washington installation FAPs and local child protective services. Mutual mandates for formalized agreements will assist in bringing family advocacy program and child protective services to the table more frequently to ensure that each party is clear on their roles, jurisdictions, procedures, and capacities. Having increased communication formal agreements between the 2 agencies as proposed by Senate Bill 0369 ultimately will fortify our coordinated community response, therefore increasing safety for Maryland's military children. Thank you for your time.
All right, excellent. With that, that concludes the panel testimony for Senate Bill 369. Look around the committee for questions. Seeing none, thank you, Senator Peters. And with that, that'll conclude the bill. Hold on, here we go. Senator Bailey.
Thank you. And just one quick question, because in my district, I have different installations. One of them has concurrent jurisdiction with the state. So the state officers can go onto the military base. They can operate just like the military police. And the other one, which is Pax River, on the original Pax River, that is solely exclusive jurisdiction. It is federal. So the state laws do not apply on the federal property. How would that be an imposition to this MOU at all?
Senator Bailey, and then we got Mr. Arnold. Senator Bailey, you're up. And then, all right, so Mr. Arnold, I think there you go.
Roger, and Senator Bailey, thank you for your service, and Senator Huff and Senator Castley as well. For those who are unfamiliar with the state liaison office, we work 10 issues that are identified by the service secretaries and the Secretary of Defense. And, the top 10, something never really falls off unless it's OBE or adopted by 40 or more states, but we do have to make room, for new mission requirements. And we have a 2-year window. The issue of concurrent jurisdiction was actually identified last year and is going to be, in the top 10 in next year's issue package for DoD as we look at, retrocession from the various installations. And I see it, Pax River, their installation, staff judge advocate has been working with local authorities on coordinating or pre-coordination of retrocession to establish concurrent jurisdiction when it comes to matters of, juvenile justice. That being said, as it pertains to the bill in front of us, Senate Bill 369 and House Bill 646, we're talking about instances that occur off post and off installation. So under federal law, Talia's law being the most recent example, anything that would occur on installation, a service member, a person in chain of command, civilian on post is a mandated reporter. So that we're actually talking about, reciprocity of information sharing from the local child protective services unit, from the victim advocacy standpoint, so that information can travel. And then also from a suitability determination standpoint in terms of finding out, at the time of an allegation rather than adjudication, for the purposes of security clearances and access to sensitive compartmentalized information and things of that nature. So for any further context or clarity, I will open it up to my fellow panelists from the Navy and Air Force.
Anyone else wish to chime in, or is that solid? Good to go? All right.
Thank you for that clarification.
Excellent. All right. Looking around the panel, Senator Jackson, you're good. You don't have anything, look like you wanted to chime in. You're good. Okay, solid. Okay. All right. With that, that's that concludes the testimony in the bill hearing for Senate Bill 369. Thank you, Senator Peters, and thank you to the panelists. Good to see you all. Excellent. So with that, we'll now move on to Senate Bill 474 with Senator Eckert. You're up.
Thank you very much, Mr. Chairman, Mr. Vice Chair. I'm glad to be here. For the record, Addie Eckert, representing the beautiful Middle Eastern Shore. And I'm here today with a significant issue that we've encountered in our counties, and that has to do with real property sale of motorhome parks notice requirements. This bill essentially extends the time frame that a mobile park owner must provide notice to the sale of a park. Currently, the law requires that a mobile park owner provide notice of sale of a mobile home park to each resident by hand delivery or certified mail, as well as the Department of Housing and Community Development within 5 days after entering into the contract. The owner must post notice of a sale in a public area of the park as well. Since establishing that 5-day requirement, we've learned that 5 days is not enough to notify the residents in the park of the sale of the park and any potential rent increases. Senate Bill 474 extends the notice requirement to 30 days before the date of the sale. This bill passed the House unanimously last year, but did not get a hearing in the Senate because we adjourned early. So Senate Bill 474 will protect Maryland's vulnerable populations who live in mobile housing, including those who've been disproportionately affected by the COVID-19 pandemic. Thank you for your deliberate consideration. I respectfully ask for a favorable report. Thank you.
Excellent. Thank you, Senator Eckert. Always good to see you. And you were the only witness here. So with that, we'll open it up for questions from the committee. Seeing none, that will conclude the, oh, actually, here we go. Senator Castley.
This is just a question on just understanding. So this is under the section says a park owner that enters into a contract of sale for a mobile home park. Wouldn't that be a purchaser instead of the owner? I mean, they entered into a sale of a contract for, I mean, it's in the existing statute, but I'm not understanding that. It says I'm a park owner and I've entered into the contract for the sale of a mobile home park. Shall within, well, I guess,
right, I think
because 5 days have gone by, so you're now actually an owner because you can go ahead and do the sale and you own it. I guess it's answering my own question.
Yeah. What happens many times when that person comes in, they increase the rents.
Yeah.
And gives the owners of the mobile home.
No, I have no problem with the logic of what you're doing. I'm just looking at it's almost should say a park owner who entered into. I mean, because anyway, okay, just sort of awkward. All right, I'm fine. Thank you, Mr. Chairman.
Thank you.
Excellent. Thank you, Senator Castley. So with that, seeing no further questions, thank you, Senator Eckert. And with that,
thank
you.
Have a good day.
You too. Have a good one.
Thanks.
And with that, that'll conclude the hearing for Senate Bill 474. We'll now move on to Senator Bidle with Senate Bill 488. Senator Bidle, you're up.
Thank you very much. Thank you, Chairman Smith, Vice Chairman Wallstreicher, members of the Judicial Proceedings Committee. For the record, I'm Senator Pam Botto, representing District 32, the beautiful BWI Airport. But my bill today is really, I think, will be voted the easiest bill of the session. It comes to us from the Clerks of the Courts Association. It's just asking to update the current way that they file wedding certificates, marriage licenses, to call it Party 1 and Party 2, not husband and wife, as we know things have changed a little. So Party 1 and Party 2, and allow the marriage license book to be an electronic record. So I have with me, I think, two witnesses, Scott Poyer, the clerk of the court of the Circuit Court of Anne Arundel County, and Mahasan Al Amin, clerk of the court of the Circuit Court of Prince George's County. And if you have any questions, I'll be staying through the hearing. Thank you.
Excellent. Thank you, Senator Beidle. And your primary witness was Mr. Poyer. So good to see you, Mr. Poyer. You're up next, and you've got 5 minutes as the primary witness.
Oh, thank you, Chairman Smith, Vice Chair Walt Stryker, members of the committee. For the record, my name is Scott Poyer, and I'm the clerk of the Circuit Court for Anne Arundel County. And I am here testifying today on behalf of the Maryland Circuit Court Clerks Association. It's the association that represents all of the elected clerks in Maryland. Our Clerks Association supports SB 488 because it updates 2 sections of the family law article related to marriage licenses and records. Specifically with regard to the first update, Family Law Section 2-403, Forms of Licenses. It currently requires the applicant for a marriage license to list the names of the husband and wife on the application. In order to bring this section into conformance with the state of Maryland's Civil Marriage Protection Act of 2012, which allowed same-sex marriages, SB 488 proposes to change the words husband and wife on the application form to Party 1 and Party 2. This change would also bring this form into conformance with all the other judiciary forms related to marriage licenses, which simply list the names of the couple and do not require that one be designated as the husband and the other designated as the wife. My colleague, Clerk Mahassan Al-Amin, will discuss the second update in more detail. Our association hopes that you will look favorably on both updates to the family law article proposed in SB 488, and we would like to thank Senator Beidle for sponsoring this bill. Thank you very much.
Thank you, Mr. Poyer. Good to see you again. And next we'll have Ms. Al-Amin. You are up next. Good to see you.
Likewise. Thank you, Chairman Smith and Vice Chair and members of the committee for this opportunity to testify in support of SB 488. For the record, my name is Mahassan Al-Amin, Clerk of the Circuit Court for Prince George's County. Like my colleague, Clerk Poyer, I am testifying on behalf of the Clerks Associations, whose members unanimously support this bill. Our Clerk Association supports SB 488 because it updates 2 sections of the family law article related to marriage licenses and records. It also brings it in line with our current business practices. Specifically, regarding to the second update, Family Law Section 2-501 Marriage License Book currently requires that each clerk keep a marriage license book. As you know, the Clerk of the Circuit Court is responsible for maintaining the court's records. That includes case and non-case related matters, including marriage license applications and the actual certificate. While official marriage license records were kept in a book format, paper book format for many years, the transition to electronic records occurred years ago. SB 488 updates the statute's wording to accommodate for modern technology to allow for marriage license records to be kept in a marriage record book or an electronic record. It should be noted that this update gives the clerks the option to record the records in a book or use electronic record. Either their process would maintain the records for historical purposes. And there are systems in place to ensure the records are secured. This includes being stored with the Maryland Division of Vital Records and Maryland State Archives. This update is also in line with the judiciary's efforts in its electronic case management system. Our association hopes you will vote favorably on both updates to the family law article, and I look forward to answering any questions you may have. Thank you for this opportunity to comment on the bill.
Excellent. Thank you, Ms. Al-Amin. So that with your testimony, that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel. Mr. McAvoy, you are up.
There we go. I'm unmuted. Hear me okay now?
Yes, we can.
Great, thank you. As someone who's been following Chief Morrissey's work with MDEC, I think that the upgrading of the systems is great, but I don't see that as the substance of this bill. It seems to me that just to state that we're updating things is to minimize what is a radical change. By my calculations in Maryland and the country, 99.8% of marriages will be husband and wife. And so the idea of using 0.2% for other, I think, is completely appropriate for this. I think it's completely able to be captured digitally. And I would urge you all to reject this bill. I thank you for your time.
Excellent. Thank you. All right. With that, that'll conclude the testimony for Senate Bill 488. We'll turn to the committee for questions. Seeing none, Senator Beidel, thank you very much. That'll conclude the hearing for Senate Bill 488. Thank you, Senator.
Mr. Chairman.
Thank you. All right, now we'll move on to Senate Bill 504. That's me. So good afternoon, committee members. This is Senator Smith here to present Senate Bill 504. Now, this bill actually, the idea for this bill came over the summer. I had a case. I got pulled onto a case from our New York office. It was actually an employment discrimination case of sexual harassment, but one of the retaliatory actions were taken was that after a drug test, a company-wide drug test, this individual popped positive, and they were subsequently terminated from their position. Now, in New York, there's a point of fact for the case was to determine whether the employer had noticed that that our client was a medical marijuana patient. And so in New York, we ended up getting her some relief because they were indeed on notice, and they have something called the Compassion Care Act, under which medical marijuana patients are deemed to have a disability and therefore protected under the New York State human rights law. So New York employers with 4 or more employees are prohibited from terminating or refusing to employ an individual on the basis of his or her certified status as a medical marijuana patient. And under New York, their act doesn't bar enforcement of the employer from prohibiting an employee from performing his or her duties while they're impaired by a controlled substance. The act also doesn't require any persons or entity to do any act that would put that person or entity in violation of federal law, or cause them to lose a federal contract or federal funding. And so that's where the idea for this bill came from. So I did some research into Maryland, and there wasn't an explicit protection for medical cannabis patients. So again, just this based off some of the medical cannabis, the Maryland Medical Cannabis Commission, from 2017 to 2018, the number of patients from Maryland increased 376%, from 11,000, a little over 11,000 patients to 54,000 patients. And from 2018 to 2019, it increased again by 71%, from 54,000 patients to 93,000 patients. Today, according to the data on the Medical Cannabis Commission's website, there are more than 125,000 certified patients in Maryland. So the premise of the bill is medical cannabis patients, they need protection from discrimination and the stigmatization that comes from them seeking this medicine, and the relief that they need to be productive members of society. And as is noted from the testimony that was submitted by the Medical Cannabis Commission, individuals with other medical prescriptions can seek protection from discrimination under the ADA, but those protections don't exist here in Maryland or anywhere in the country because cannabis is still considered to be a Schedule I drug. 12 states and the District of Columbia have already moved forward with similar protections, as I mentioned, New York being one of them. And again, in some of the testimony submitted by the Cannabis Commission, they cited the Maryland Health General Article, Section 1333-13, which sets forth protections for medical cannabis patients that they may not be denied any right or privilege. And that could be construed as some sort of thin protection. But if you go to their website, they explicitly say that medical cannabis patients are not protected from this type of discrimination. So what does the bill do? The bill prohibits an employer from discriminating in employment against an individual who has received a written certification for the use of medical cannabis under the Maryland Health General Article, or has tested positive for cannabis if the individual holds that written certification for medical cannabis. So under this bill, an employer may not fail to, or refuse to hire, discharge, or otherwise discriminate against an individual with respect to their compensation, terms or conditions of privileges, limit, segregate, or classify its employees or applicants for employment in any way that deprives or tends to deprive that individual of employment opportunities or other adversely affects their status as an employee. The bill does not, much like New York, it does not prevent an employer from prohibiting a patient of medical cannabis from being under the influence during their work hours or in the performance of their work duties. And it does not require that person or that entity to hire someone if it would violate federal law, regulation, or cause them to lose money or licensing related to any other benefit under federal law or regulations. And with that, that's the sum and substance of the bill and the purpose why we need it. So with that, I'll turn it over to the panel, and then I'll stick around obviously for questions. The first panelist is Ms. Wong. You are up. I see you there from the University of Maryland Law School. You're up. And as the primary witness, you'll have 5 minutes if you like.
Hello. Thank you, Mr. Chairman and members of the committee. My name is Edka Wong, and I'm a student attorney at the Public Health Law Clinic at the University of Maryland Carey School of Law. Today, I'm here in support of SB 504 for 3 reasons. 1, this bill reinforces Maryland's decision to legalize medical cannabis. 2, it enables medical cannabis patients to take their medication without fear of reprisal at work. And 3, passage of this bill would place Maryland among the other states that have adopted affirmative protections for medical cannabis patients. In the state of Maryland, other states across the country, the law has recognized medical cannabis as a legitimate treatment option. As such, why should medical cannabis patients be treated any differently from other patients who use legitimate medication? If medical cannabis is used off-duty and does not cause impairment at work, the use of medical cannabis does not present a safety concern. Therefore, it should be treated as any other medicine and protected by law. This bill also protects medical cannabis patients who test positive on a drug test. This is critical because it allows those patients to take their medication without fear of adverse employment action. It is important to note that a positive drug test alone is not indicative of impairment. Studies have shown that the effect of cannabis on cognitive function is minimal in frequent users. Furthermore, if an employee was impaired on the job, this bill would not prevent the employer from implementing policies and procedures to prohibit such activity. Ultimately, Maryland law should not force an individual to choose between keeping their job and taking their legally sanctioned medication. Additionally, the protections afforded by SB 504 are narrowly tailored to ensure the safety of others, the employer's rights, and the well-being of the employee. Specifically, this bill does not require the employer to provide protections for patients if doing so would violate federal law or place the employer at risk of losing their funding sources. With these narrowly tailored protections in place, this bill not only protects employees, but also reasonably accommodates employers. Finally, it is important to point out that the protections offered by this bill are not uncommon. 13 other states and DC have provided employment protections for medical cannabis patients. Maryland should adopt SB 504 and join the rising tide of states that recognize medical cannabis as valid and necessary and provide employment protections for those patients accordingly. Thank you so much for your time.
Excellent. Thank you, Ms. Wong. And since you're under 2 minutes, my apologies, Ms. Katsky, you're next. You're from the Medical Cannabis Commission, so please feel free to chime in here, and good to see you, and thank you for your testimony.
Great, thank you so much, Mr. Chair, Mr. Chair, members of the committee. Thank you all for your time today. My name is Taylor Caskey, and I'm the Director of Policy and Government Affairs at the Maryland Medical Cannabis Commission, here today in support of Senate Bill 504. Mr. Chair, you really took the words out of my mouth and made my job super easy today, presenting the federal implications for our patients and how they don't have protections, how so many other states have already implemented these explicit employment protections for employees who are also medical cannabis patients. So thank you so much for introducing this important piece of legislation. Personally, I receive several calls and emails a month from employees and employers alike, seeking further guidance, asking questions about what they can do. And for the most part, we're unable to provide any guidance, because we don't currently have these explicit protections in law. So this bill really just provides those explicit protections for our medical cannabis patients, and also provides equal protection for the employers. So it's really an excellent balance of all the interests involved. When you look at the other states that have provisions like this, SB 504 is really one of the most, if not the most comprehensive laws, because it really does just address every possible interest group and every possible concern. So keep my remarks brief. I'm happy to answer any questions. And with that, I thank you for your consideration today and urge a favorable report on this bill.
Excellent. Thank you very much. And with that, we'll go on to Mr. Xavier, you're up next.
I'm not sure why my camera is not functioning here, but I'm Joe Xavier, CEO and Senior Consultant for Summit Sustainability Solutions. Okay, there it goes. And for me, this is not about discrimination or rights. I'm not testifying or judging any of that. It's about safety, and it's about safety that we need people to not be impaired, to not have slow to reaction time, to not have an altered depth perception, and to have full use of their motor skills and coordination. So for us, it's more of just emphasizing paragraph G that you have in the bill and strengthen the language of paragraph G until we have an effective, accurate, timely, cost-effective mechanism to test for the impairment of cannabis, that we would like to have cannabis just clearly stated as being prohibited within the construction industry. Thank you.
Excellent. Thank you, Mr. Xavier. And now we'll go on to, do we have Vince McAvoy? Are you still with us?
Yes. Can you hear me all right now?
You can, yes.
Great. Thank you. Folks, for the benefit, and thank you, committee, and thank you, chair, for the benefit of an affirmative defense or the issues of a positive drug test regarding impairment, I would urge that the juice isn't worth the squeeze, to borrow a saying you all use a lot down there. Because are we concerned about them being impaired enough for surgery, or impaired enough to operate a light rail train, or taking care of disabled children? I point you to my written testimony on this, which shows a case of Amtrak discussing intoxication leading to death in their crashes. The famous crash into the BWI by a light rail, where the operator confirmed that he had used cocaine and marijuana. And there was another one as well. So I'd invite you to look at that just to get an idea of what this could be, because it's going to be a constant liability for the workplaces, and for the owners are going to have to be discerning different stereotypical characteristics of various intoxications. Is this a medical marijuana intoxication? Is it something different? And splitting hairs on that. And it's also going to allow drug addicts to use that as a potential excuse, which we don't want under any circumstances. So senators, I would say, if your constituents are concerned about daily safety issues and daily quality control concerns and drug use, drug dealing in the various workplaces, that was the last example I gave you on the written, daily performance measures, higher level thinking, and accountability, then you'll probably want to vote against this bill. So I thank you for your time.
Excellent. Thank you very much. And with that, Francisco is not here. I do have a question for the panel, but I'm going to defer to my committee members first, colleagues first. Senator West, go ahead. You're up.
Thank you, Mr. Chair. So about 18 months ago, before the last session of the General Assembly, I drove down to Montgomery County and went to their police training facility and spent the better part of a day, along with Senator Kagan, experiencing how police are trained to identify marijuana. And I will tell you that my takeaway from it was, it is really, really tough and very subjective for even trained policemen to accurately ascertain whether an individual is under the influence of marijuana. And then, of course, there are gradations of being under the influence of marijuana. So I understand that that you can take blood and then have blood tested. This takes quite a while, and then you can figure out from the blood test to what extent the person is under the influence. So I guess, Ms. Caskey, since you do this for a living, how in the world, if this bill were to pass, would an employer be able to tell whether an employee arriving for work at 8:30 one morning was under the influence of marijuana or not?
Ms. Caskey, before you answer, my questions are pretty much along the same lines of thought. So my question then is, there are obviously a lot of legally prescribed medications that have explicit warnings, not to operate in a vehicle and so on and so forth. And so because of obviously medical cannabis is, it's still Schedule 1, not protected by ADA and some other protections, employment protections. So my question then is can you explain that regime? Are people that are legally prescribed medications that could alter some of their senses, are they protected? And if you could draw those similarities, that'd be great.
Sure. Yeah. So these are both excellent questions, and I'm going to do my best to the extent that I can answer now, and always happy to follow up with additional information. Specifically, Chairman Smith, regarding your point too, how do other types of pharmaceuticals that might also have lingering effects? I'm thinking of certain sleeping medications, maybe antidepressants or something like that, where you do see these warnings of don't operate a vehicle, don't operate heavy machinery, things like that. I don't have an answer for that in terms of how the ADA or other federal protections would then transition over into employment protections, but I'm more than happy to engage some of my staff, and I personally will do some research, and I'm happy to provide the entire committee with information on that, because I'm sure it is out there, right? Like it can't be something that this is the first time this is coming up. So again, I'm more than happy to do a little research to get you more information on that. And I think that will tie in, Senator West, to your question. As has been pointed out, we do not currently have a good way to judge impairment, the same we do with alcohol, where it's very easy and you're looking at a breathalyzer or something like that. And so I think it is important, though, to the extent to keep in mind that medical cannabis is more akin to other pharmaceuticals than it is to alcohol, to the extent that people are using it medicinally versus recreationally. And with this bill and the language in the bill, it does allow employers a lot of leniency and leeway in terms of drafting their own individual policies for how, for their drug-free policies, and how that would then carry into medical cannabis use and potentially other pharmaceuticals as well. So all that to say, I wish I had a better explanation and a more explicit answer for you at this time, but I'm happy to do additional research and look into it and answer, any follow-ups.
Absolutely. And Senator West, I can provide that research to you as well. We can work together, but I have some of that. And we had this exact discussion and question is, if you're high on, pain pills, for instance, on pain pills, how would your employer be able to tell that you're under the influence of, what test would you have apart from drawing blood? And so it's the same type of conundrum that exists with prescription medication. But obviously if someone's under the influence and you can make that inference or deduction, then the employer has a case to terminate you for that, for performing your job functions under the influence.
My understanding is that you can do these tests, and then the employer can tell whether or not you have marijuana in your system. But the tests don't delineate whether when you ingested the marijuana, and to what extent at varying periods of time you may have had so much marijuana in your system as to be under the influence. So that's, if I'm running a construction company or a trucking company, the last thing I want to do is have someone on the road who has so much marijuana in their system that they're not capable of safely driving the truck or operating the construction equipment. And so my question is, when someone comes to work and they've tested positive because indeed they're using marijuana for medical purposes, how is an employer to determine whether or not at that particular time the employee has so much marijuana in the system that they should not safely operate the construction equipment or drive trucks on the road?
So, that's another thing too. We have to get to you're gonna have remnants of cannabis, even if you've ingested 24 hours ago, 48 hours ago. So
Probably 5 days ago.
So that's again, that speaks to your point of the lack of a real comprehensive way to test. But I think I just draw that parallel to other legal prescriptions in medicine that you wouldn't operate machinery under, if you've taken it, or you wouldn't perform your normal regular duties. The same thing, we're just asking for the same level of protection for a safer method of medication.
It strikes me that if somebody, for example, has to take medication for epilepsy, that maybe that person would not be a good candidate to be driving a truck on the highway.
I'm pretty sure
take the epilepsy medicine, all of a sudden you could have a seizure on the road.
I suspect if you had epilepsy, you wouldn't get a driver's license and or a CDL. But so yes, Senator Sidnor first, and then Senator Jackson.
Thank you, Mr. Chair. This is a question for Ms. Kasky. You had mentioned drug-free workplaces, and I'm curious, given that Maryland has a number of companies that contract with the federal government, what's your experience and what have you seen in how they are able to ensure that their policies align with their contractual responsibilities under the drug-free workplace contractual provisions?
Sure, yeah, and that's another great question, and something that is addressed explicitly in this bill too. So if you do have a federal contractor, I mean, right now, and I suspect even if and when this bill passes, it would remain the same, that when you do receive federal funding, if the federal funding would be impacted by one of the employees, either status as a medical, not just status as a medical cannabis patient, then the employer would be under no obligation to then hire that person, right? And so that's the same thing that happens now when you have these blanket drug-free workplace policies that prohibit folks who are medical cannabis patients because they might test positive from being hired. And so that's one of the excellent things about this bill, is that it does have those express provisions built in to protect any federal contractors or folks who receive federal funding from being put in a position where that funding might be compromised based on someone's status as a medical cannabis patient.
But this, and maybe I was misreading it, I was assuming that this was not just a bill about hiring, but also workplace in general. So let's say I got a prescription, but I have an employer who is under this obligation from the federal government. They may look at me as a risk to their contract and let me I guess they could let me go. And this bill wouldn't necessarily protect me in that particular case.
Right. Yeah, that's correct.
Thank you.
Got some work to do in the federal government first, Senator Sidnor. We're working on it. All right, Senator Jackson.
Thank you, Mr. Chairman, and thank you for bringing this piece of legislation. And thank you for the questions from my colleagues. A few have been asked. I think when you look at a piece of legislation such as this, well, first, the Senator West spoke of going to the Montgomery County Police Academy. The Maryland Police Standards Commission has been wrestling with the marijuana issue for quite a while, because there are some states that have legalized recreation marijuana. So that's been a challenge for law enforcement, continues to be a challenge. To get to my question, from a workers' compensation standpoint, should something occur with an individual and they are prescribed medical cannabis, and so I think the bill indicates that there's some protection under a disability statute, correct? Is that correct? I'm trying to get to the workers' compensation component. So if I'm an employee and I have a medical condition and I am prescribed cannabis for medicinal purposes. However, as Senator West mentioned, if I'm a truck driver or if I'm in a position where I cannot operate certain equipment, is there compensation? Is there an ability for the individual to be compensated, or do they lose their job? So, in a lot of professions, if you are on light duty, you can't be on light duty indefinitely. Somewhere along the line, you have to get cycled out. So are there protections built in into this law? I guess just to the proposer of the bill, Mr. Chairman, or?
So I think, let me just rephrase the question to make sure I understand it correctly. So it's essentially if you are dependent or you've sustained an injury or some sort of ailment and you have now availed yourself of medical cannabis and you need that to get through your daily regimen, then are there protections for the employer for saying, hey, look, if you are a medical cannabis patient, we can't have you driving this tractor trailer? You're saying are there protections for that employer? Or
are there protections for the employee and the employer, right? So if I have to separate, so if you're in certain, so from the law enforcement or military, law enforcement world or military world or public safety, a person cannot be indefinitely on light duty sitting on a desk if they are hired as a public safety individual, right? So somewhere along the line, the person is retired medically, whether it's disability due to some workplace incident or a medical. So is the employer protected should that happen? And is there something for the employee?
So, two things. It's a reasonable accommodation thing keeps creeping into the JPR stuff this year. But if that employer, makes that reasonable accommodation, then, no, they're not going to be on the hook. But the language that we took from, hey, you cannot be under the influence, that's borrowed. I mean, that's borrowed language that we dropped in here so that there is protection and it's explicitly clear that the employer can't operate or you can't perform your duties while you're under the influence, which is why I think Senator West's question is pretty revealing, because it's the same dichotomy with prescription drugs. You wouldn't know. There's no easy way to test whether someone is under the influence or is under the influence of prescription drugs or medical cannabis. There's no easy way to do that. So I think that's the dichotomy. That's kind of like the position. I think that's why I think Senator West's question was pretty spot on. Was good. It identified one of the kind of the conundrums of all prescriptions, cannabis or otherwise. But yeah, there are protections for the employer. If you've made a reasonable accommodation to help someone with a disability, but also the language that we dropped in to prohibit, their performance of work when they're under the influence. I think that answers your question. I think it protects both ways.
Okay, cool. Thank you.
Senator Cassidy. Sorry, there you go.
I think, is Mr. Xavier still there? I see his camera's on. Can you just unmute?
You're still there. He has to unmute you. There you go.
Hi, Mr. Xavier. So what's your position again? What do you do? I kind of missed that.
I'm sorry, I didn't catch that last statement.
Yeah, what do you do? You're here as what? What's your role in life? What do you do? You're here testifying, but what's your profession? What do you do?
I'm sorry, I was just switching from the other testimony. Senator Kessler, are you speaking to me, Joe Xavier?
Yes. Okay. I'm trying to find out who you are. Yes.
Okay, I apologize for that. I'm Joe Xavier. I'm the senior consultant for Summit Sustainability Solutions. I run a safety consulting company specialized in the construction industry. I worked for Maryland OSHA as compliance officer and later as a training education specialist during the Glendenning administration, and then went to work for bakeries in the Baltimore area, served there for 8 years, and then started my own consulting company.
Okay, no, that's good. Your role in the construction industry, are you pretty familiar with the comings and goings in that industry right now?
Yes, I have several clients within that industry.
Okay. I haven't worked in construction for many years now, but many years ago when I did, I mean, marijuana was just everywhere all the time. I mean, not by the folks operating the cranes and the heavy equipment, but certainly on the laboring side, that was sort of the recreational drug of choice, even over alcohol. Is that still the case in that industry?
I would not be able to testify to that.
Okay. That's what I was trying to figure, if you
know
how
that,
much you know about the industry.
Right. Well, one of the things that we do is that we're very proactive on substance abuse and having EAP programs and encouraging people to not abuse those different substances. The people I work with are at Associated Builders and Contractors, and we have some very strong programs preventing substance abuse. And we spend a lot of time talking and educating and working with the workforce to prevent any kind of substance abuse.
Well, is the substance abuse a big issue within the building trades then? If that's your position, you're getting paid to stop it. So I assume there's some abuse going on.
Yeah. So according to the ABC National, the national office, they did a report for the year 2020, and in their safety performance report, they quoted that about 1/3 of work-related injuries in construction are somehow related to the use of drugs or alcohol on the job site.
And do they, in that report, do they discuss what kinds of drug or alcohol, or are they just generally all drugs and alcohol, mix it all together?
It just aggregated all the different drugs and alcohol.
Yeah. Yeah, I mean, you pointed out the challenges with this last paragraph, and the chairman was hitting on as well as Senator West, that just detecting impairment, intoxication levels, what have you, on cannabis is not the state of the art right now. And yes, it's fair to say that currently in the industry, if I'm going to be operating that crane, that if it goes if I do something wrong, it may squash, 30 laborers to death in 3 seconds without any warning. Or if I'm operating one of those huge dump trucks that I see out there that must weigh just god awful numbers of tons that could roll over a human being without even a blip in the tire, that they probably have a pretty zero tolerance, that if as opposed to somebody who's, responsible for, using a shovel or something, that you would have zero tolerance for that. And that's probably the only way they can get around that. I guess that's where it is right now, right? Right. And there are some jobs that are regulated. For example, if you're building a pharmaceutical, if you're constructing the building, they're regulated by the FDA. And we were on a job site, and before any employee was allowed to walk through the gate, you had to go to a safety orientation, which I supported, obviously, site safety orientation, as well as a on-site instant drug and alcohol test. So that was before they let you into the gate. And that's everyone. That's some of the things that we're dealing with in the construction industry, is that we have those requirements of certain clientele. And then there were also, other laws and other regulations that affect different types of work sites. Okay, thank you. Our issue is that what you mentioned, the fact that there's just no test. How do we test for impairment? So I liked paragraph G quite a bit. Like I said, it's just we were asking for additional layer of protection until there is that test that's available for impairment. Thank you.
Thank you, Senator Castley. And so I view that. I mean, there are some amendments that Exelon even they put forward that I think could be construed as a favorable amendment to look into it. But this amendment here, I would consider to be an unfriendly amendment, and I will not accept it. But I think that we've already made the determination that medical cannabis is medicine here in Maryland. Like we've already made that policy call in Maryland. And so if you're going to say that something's medicine, all this bill does is put it on parity with every other pharmaceutical medicine and say, look, you cannot be discriminated because you are a patient. We've already made that policy in Maryland. And as far as the drug tests, if you're on Oxycontin or Adderall or give me a number of other drugs that you would use for pain management and a number of other ailments, that drug test wouldn't have detected any of that. And so those people could have walked onto those work sites having just recently ingested and downed, a number of pills that would alter their judgment and physical and cognitive ability. So I'm just, let's at least put this on parity. If we're saying that medical cannabis is medicine, all we're saying is that you cannot be discriminated because of that status. And
but Mr. Chairman, doesn't that ignore the reality? I mean, aren't we that in these industries where they don't have the ability to determine intoxication, their only choice is to have a zero tolerance because it's the only medicine that people abuse. You don't abuse sleeping pills for recreational purposes. Most of the other things, it's not a recreational component, but clearly marijuana has a long history of also having this other use in addition to medicine, to having a strong, especially in the construction industry, to my knowledge, of being widely abused, and where the results of an abuse of that can be terribly catastrophic, and little kids with no mommies and daddies because they got squashed flat like a pancake. So in certain industries, the potential for catastrophic outcome just sort of justifies a zero tolerance. And we're saying, well, aren't we really saying we're going to pretend? We're going to pretend that marijuana is not recreational. We're going to pretend that it's not widely abused in the construction industry. And we're going to pretend that everybody's going to come in home at night, even if that's gone. I mean, it's just that's it.
I must admit, I don't know what the social or proclivities of folks in the construction industry, what they do, behind closed doors and what medications they pursue. I'm ignorant to that fact, but I do think a legitimate dispute over just fact of which line of whether pharmaceuticals or medical cannabis, which is more harmful or more addictive. I mean, I think the studies are actually pretty clear on the addictive qualities of pain medicine, and not only in the military but in athletics. I mean, I think the science is pretty strong on that. So happy to furnish the committee with volumes of study on that. But
thank you.
Thanks, Senator West.
I think we're sort of winding down. I just wanted to add, I've now noticed that this particular bill is written into the racial discrimination part of the code, and the penalties for discriminating on the basis of race are rather draconian, as they should be. There's nothing in here right now about discriminating on the basis of taking medicine or prescribed medicines. This would be putting the marijuana thing into and making the penalties to an employer just as serious as if the employer were engaging in race discrimination. I'm not sure that this is the best part of the code where this bill, if it's passed, should be codified. And if it is codified in the code, it seems to me we ought to consider what enforcement or what penalties would apply in the event that an employer were to be found to have failed to hire an employee because he or she's tested positive for marijuana, and the employer shouldn't have done that. I suggest that the penalty should not be as serious as if the employer is found to have engaged in race discrimination.
You know what? That's a fair point. And the reason why this is the case is because it's modeled, but the language was taken from New York. And as I mentioned before, in New York, they qualify as you have a disability if you're a medical marijuana patient and therefore protected there. So happy to work with you on that. It's a fair point. I'm not sure what you move it to you move to Health General. I don't know how that works, but I'll sit down and figure that out. That's a good point though. But that's where it comes from. It comes from the New York language. So of the, I guess, 13 or 12 states that operate that way, Senator West, I'd say I'm just going to do a quick count. At least half of them have the same scheme, right, as a protected class, so to speak. I don't know if you can hear me. But,
no, I can. I'm making notes.
Yeah. So I think a little over half of the states that have enacted this have used that scheme. So something to consider. All right. Looking around the room. Seeing no further questions, thank you all very much. That concludes the hearing for Senate Bill 504. We'll now move on. Thank you all for the panelists. Thank you all for coming by. We'll now move on to Senator Carter. It's going to be the Senator Carter show for the next 3 bills. Senator Carter, you are up with Senate Bill 394 next.
Thanks, Chairman Smith, and thank you, committee, for your endurance. I really appreciate your attention to these bills. I will try to be interesting and brief. The first bill, Senate Bill 394, is not a bill I would typically sponsor. Reason being, I am a big proponent for judicial discretion, however it works out. I generally favor judicial discretion, and I don't favor taking away any discretion from a judge most of the time. However, in this instance, relating the issues related to this bill, I was convinced by Delegate Shanika Henson, who worked for the Office of the Attorney General and the Child Support Division, that this bill is actually necessary. And so briefly, I'll give my testimony, hear from, I think I only have 2 panelists, and then answer questions. So all this bill does is close a loophole in the law and that currently allows for consecutive sentencing for child support arrearage cases. This bill would simply call for concurrent sentences, not consecutive. It would be a prohibition against a judge ordering consecutive sentences for child support. Now, why would we want to do such a thing? Well, the first thing, when a parent is serving a prison sentence, the parent is unable to pay child support. In fact, we actually have laws that excuse child support for a period of time during incarceration. But even more than that, that's time away from the child. There's no data that indicates that having a parent, a non-custodial parent, serve a lengthy prison sentence does anything to enhance their ability to pay child support or does anything to get the child support paid. And so there are 2 harms that can be alleviated. One, overly incarcerating a non-custodial parent, criminalizing poverty, and also affording a non-custodial parent an opportunity to be in touch with their child and not having the inability to pay child support a reason to one, incarcerate, but also a reason to keep the parent away from the child, which often happens, of course, when they're incarcerated. Finally, I wanted to say that we would not be the only state that does this. There are other states that do this, including Virginia, which is our neighboring state we often use as a reference. Finally, is this a real problem? I asked that question of the House sponsor as well, and she indicated, yes, it is a real problem. She said that when she could document no less than, it's not a lot, it's not a huge problem, it doesn't happen a lot, but at least 12 cases that she could point to where consecutive sentencing was given to a non-custodial parent. And, we believe that that's just excessive, that concurrent sentencing for the same violations of failing to pay child support is simply sufficient. With that, I will be quiet and answer questions or defer to my panel, who is, I believe, Christopher Dews from Job Opportunities Task Force and Christine Dufour from the Office of the Public Defender. Thank you.
Can I start now, or am I waiting for questions?
Yes, go ahead. Yes, sorry, go ahead.
Thank you so much, Senator. Yes, so my name is Christopher Dews, and I'm a policy advocate for the Job Opportunities Task Force. Our mission at JOTF is always to help low-wage workers advance to higher-wage jobs, and moreover, to decriminalize poverty. So I actually testified on this bill last year on the House side, and since then, it seems like the issue hasn't really changed. I mean, we support it for the exact same reasons that we were supporting it last year. And that's that we see the idea of incarcerating somebody multiple times for the same charge, as the senator has already mentioned, as almost grounds for a cruel and unusual punishment, specifically because it's a non-violent offense. And I understand, judicial discretion, as the senator already mentioned, but when we're considering things like the fact that incarcerating somebody for a charge, if you look even at the law, I believe it's subsection C that says, that the conviction is subject to a fine not exceeding $100. I mean, if it's that serious, we're talking about $100, and then not exceeding 3 years of incarceration. That seems like a 3 year of incarceration is already strong enough that a consecutive sentencing of 3 years on top of 3 years on top of 3 years on top of 3 years just seems needlessly excessive, to the point where a person can even argue that it goes against Section 38, which I believe has to do with debtors' prisons in the state of Maryland. So there's not really much else to say. I mean, there's only about, as Senator already mentioned, only about 12 people this has happened to over the last like 2 to 3 years. And so and I think it's 6 people in Washington County, 1 in Frederick County, 3 in Calvert County, 1 in Dorchester, and then 1, I believe I'm missing 1 other person that the research hasn't necessarily shown yet. But for those reasons, we just urge a favorable report. We think that as it costs $38,000 to the state per for the taxpayer for every person that's incarcerated, the idea of incarcerating somebody multiple times for child support just seems like unnecessarily excessive and a waste of taxpayer money, and it's harmful to the family and harmful to the children. And we don't even know why these people necessarily have done this. It just seems like it's a loophole that just easily needs to be closed. So for those reasons, we urge a favorable report. Thank you guys for your time.
Excellent. Thank you very much. Next, we'll have Ms. DeFore. You are up. Good to see you.
Good to see you. Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Christine Dufour, and I'm the supervising attorney in Talbot County. My colleague on the panel is correct. You don't see these cases very often. It very much depends if the prosecutors choose to prosecute this misdemeanor crime. I have in my career seen it done in one county on numerous occasions during a 6-month period when the prosecutor decided to prosecute this in lieu of going with the non-support or failing to pay in the civil arena, which is typically prosecuted by the county attorney. I did indeed have a client get 3 years. He immediately appealed, and we got relief at the circuit court. While it doesn't happen very often, it could happen specifically in this scenario. If you're a parent, a non-custodial parent with obligations in, say, 2 children who live in 2 different counties, if you fail to pay, and here there is a component of willful failure to pay, because that would presume an ability to pay and failing to do so, one judge in one county could impose a sentence under this statute, and another judge could theoretically impose a consecutive county for the same sentence in a different county for the same act of failing to support children. We'd respectfully recommend a favorable report. The Public Defender's Office does represent individuals in criminal and civil contempt hearings. This is typically where, again, this matter is typically addressed, where you have the county attorney prosecuting it and the Bureau of Child Support is presenting evidence. However, this is occasionally sought in the criminal context, and we'd strongly suggest that any sanction that be imposed should be concurrent to any other sentence, and we'd ask that this committee adopt Senator Carter's bill and pass it.
Yes.
If there are any questions.
Excellent. With that, so we'll open up. That concludes the testimony. We'll open it up for questions. I saw Senator West first, and then Senator Castley.
Thank you, Mr. Chairman. This isn't going to sound very Republican, but what purpose does it serve to put people who have the ability to pay money and haven't done it, therefore have willingly failed to pay the money? What purpose does it serve to put them in jail? If the purpose is to get the money, why not garnish their wages, have some sort of a special injunction issued against them, requiring them to show up in the clerk's office weekly in order to be examined about what money they've earned that week and pay it over? Putting them in jail at all sounds to me like a way to guarantee that there would be no money paid, because if they're in jail, they're not earning anything. What am I missing here?
Senator West, I didn't entertain an amendment if you wanted to offer one saying no incarceration for child support arrearages, but the current bill. I agree with you. I think the point of this bill is that it doesn't serve a purpose. It certainly doesn't serve a purpose to have an excessively lengthy sentence for multiple violations, because the inability to pay is the reason for all of them.
I mean, my thought is maybe you put them in jail briefly to teach them a lesson, because they'll find out how bad it is to be in jail. You put them in jail for 30 days, and then you let them out and you garnish their wages, and you there must be other things you can do to extract the money from them if they have the ability to pay. But it almost sounds like our modern version of a debtor's prison, wherever if you're in debt, you go to jail, which means you never can pay the debt. Again, I don't understand what I'm missing, but somebody must have crafted these laws. This is the first I've encountered them. It doesn't make
This legislative body.
Maybe another Republican who really is a Republican can answer this for me.
I might have some answers for Senator West if I'm permitted to respond.
Sure, Christine, I'd love to hear from you.
Thank you. When we're doing the civil contempt docket, those type of opportunities are often given, and it's a last resort that you can be found in contempt if you've been given an opportunity to have your wages garnished, but you willfully change your job frequently so that the garnishment doesn't come into place, or you fail to work with the non-custodial MTEP program. We have a very robust Bureau of Child Support here that really works with individuals. I constantly argue all the time that, if I have a client who can't even maintain a job at McDonald's because they're mentally ill, they're not willfully failing to pay. So oftentimes the NPEP programs will work with them. The Bureau of Child Support will work with them. Very, very rarely where I have someone who's willfully impoverished themselves, for example. So in the civil context, in the circuit court dockets, those programs on alternatives are explored. But if you're prosecuting someone under this 3-year misdemeanor statute, they're not. It's jail or probation. So
if you
I
would
agree with you.
could you give me an example, just one case of where someone who owes child support has been put into jail for 3 years, and this is actually
I've had it happen.
And this is actually, and this has actually been beneficial, and it has resulted in child support being received by the person who is raising the child.
I can't offer that case.
Okay.
All right, excellent. Thank you, Senator Castley.
Thanks. Sort of questions towards Christine, but sort of going back to Senator West's question. I mean, I think as Christina alluded, these are rare. That's overwhelmingly Senator West's logic applies that don't put them in jail, make them work and get the money. It's ludicrous to throw people in jail. Overwhelmingly, that's the case. But, I'd be glad to go to the reporter and pull you out some cases, Senator West. But occasionally you do run into that defendant who is so furious that they were not awarded custody of the child because they hated her, and somehow the court felt that she was actually the better parent. And we know that person's making an income. We just can't find it. We can take pictures of him driving in his nice new Tacoma, and we know he's going to the bars and spending money, but he never has a penny for child support. And this goes on and on and on. And at some point, the court can just lose its patience. And at that point, clearly this individual isn't motivated by their lack of money to pay. They're just motivated by their animosity towards their ex-spouse, which transcends into let the little brat starve. So, I mean, come on, this stuff is out there. I guess the question I have for Christine would be more on the technical side that, so if these multiple, I guess that could be that you didn't pay, if you didn't pay for 6 months, that would only be one conviction, right? I mean, if it's the same kid, let's take the first case where it's the same child, I'm paying the same support for the same child. And could I get multiple convictions or wouldn't for the same child? Because how could I have another, if I'm still in jail, then I couldn't violate or anything while I'm in jail.
I'm not sure how it would occur under the criminal statute in this contempt arena. They have found, and sometimes we argue that the petitions go stale, that you have to have a certain time frame where you find the present ability to pay and fail to do so. And if you're trying to seek for the same child a separate contempt proceeding, then you have to show we argue that separate time frame. So you're absolutely correct. You can be found in contempt, but if the petition has gone stale, you can, and you get jail time, albeit typically no more than 140 days. And I'd have to really dig to find out where that 140-day window came from. Right. When the found in contempt in the circuit court. So separate from the criminal misdemeanor statute that we're discussing today, people do go to jail if the court finds that they're have the ability to pay and simply haven't. I literally had a circuit court judge ask a client of mine, a public defender client, wow, you look hale and hearty. How are you eating? And he was relying on his girlfriend to support him at the time. But he literally looked at my client's physique and said, you must be eating somehow, so you must be able to pay child support. So we oftentimes have to fight and argue with the courts as to whether or not my client has voluntarily truly impoverished himself. And again, I
Okay.
somebody in your you described.
So the other possibility, it wouldn't be the same multiple violations of paying child support for the same child. The other possibility is you have three children by three different mothers in three different counties. You're not paying. If we pass this, I might as well not pay any of them because it's all going to be consecutive. The most, whatever I'm getting now, it's going to be consecutive. So it doesn't get any, the fact that I'm voluntarily not paying three, and that I got three judges who are all convinced that I'm not impoverished, that I've got the money, I'm not paying it, and they each give me 100 days. Well, I'm like, no big deal because it's all consecutive. So
Concurrent, I think you mean concurrent.
I'm sorry, concurrent. I'm sorry. Thank you.
You could also have three different individuals in one county because each child's case would be separate if the plaintiff's if the mothers are different. So
Gotcha.
Three
even in the same county
in one county as well.
Yeah. I mean, it just seems like, going back to Senator Carter, going back to your initial premise that, look, A, this is rare, and B, do we really want to take the discretion away for those cases where the guy is really, or the gal, sometimes it's a gal, is just really, the money's out there and they're just toying around with it. I mean, the judge has to be convinced by a preponderance of the evidence. I don't know why we want to, I look at the judiciary's opposition. If this was happening all the time, but maybe somebody can show us where this is such a common thing where somebody in a simple child support matter is getting A, criminal time for anything, and then B, that they're getting consecutive. It certainly happens sometimes, but it seems like you would want to have that ability for the really bad cases.
Senator West, oh my gosh, Senator Castley, I'm sorry. West.
He's got hair. He's the one with hair.
I'm sorry, Senator Castley, a couple of things I just wanted to put out there. I started off by saying I had some hesitation about the bill because of the taking away the discretion, as well as the fact that it's not a common thing. But my position is that if it happens 3 times in a year, then it's too many times in a year. It shouldn't really happen at all. I've thought about this and grappled with that very rare, super egregious offender scenario that you're contemplating. And I'm thinking, perhaps there could be some type of a minor amendment that would say that, there would be an exception for the egregious repeat offender, somehow, however that's defined. But finally, I just wanted to say that I was racking my own brain for a scenario where something like this had ever happened in my career. It's been many years. But I do recall in one of the counties on the other side of the Bay Bridge, I don't remember which one, many years ago, maybe more than 10 years ago, I represented someone who got probation. So the judge would suspend the sentence for the violation of the contempt for the violation of the child support order, suspend the sentence and put him on probation and say, just get employed and pay your money. And then, the next year charge brought again, next year charge brought again. The same child though, that I recall was the same child. It's just that the suspended sentences ultimately became actual sentences because like on the 3rd or 4th time, the person still wasn't able to pay. So that's a scenario where it could be actually the same child, but just multiple violations that ultimately wind up in consecutive sentences. And, that particular person, I'm pretty sure, I don't know what happened to him, but he was struggling to get a job and pay money, I recall, because he had, a criminal record and he just couldn't keep stable employment. And that was his situation. I'm sure that happens quite frequently. I'm sure this is more common with people that can't pay than it is with that rich person that just doesn't want to pay.
Thank you. Appreciate it.
Excellent. Thank you, Senator Castley. Looking around the room for further questions. Seeing none, that will conclude the hearing for Senate Bill 394. We'll now move on to Senator Carter with Senate Bill 401. Senator Carter, you're up.
Mr. Chairman, I have a request, if you'll humor me. So my request is, could I move to 402 before 401?
Of course.
Would I do such a thing? Because the subject matter is kind of similar and some of the witnesses are the same. If it's okay, if not, if it's going to mess something out, I'll do 401 first.
No, at your pleasure. 402, we'll go to 402. So Senate Bill 402, Senator Carter.
Thank you, Mr. Chairman. Hopefully this will not be too long of a bill either. Hearing. So Senate Bill 402 would take away the sanction of driver's license suspension for failure to pay child support altogether. Mobility is key in Maryland's regional economy. The Census Bureau reported that 50% of Marylanders travel outside their county for employment. This statistic is more pronounced for lower income communities of color where there is a scarcity of jobs available by public transit. Am I in Annapolis? In fact, only 9% of jobs in the Baltimore region can be reached within 1 hour. Thus, for economic sustainability, both a valid driver's license and a vehicle are a necessity. In 2015, NPR reported that 62% of Marylanders who owe child support make less than minimum wage, but owe at least $10,000 in unpaid arrearages. Although African Americans make up 31.1% of Maryland's population, the Maryland Department of Transportation data suggests that they owe up to 71% of license suspensions they made up 71% of license suspensions between 2015 and 2020. There's no evidence that suggests that suspending an individual's driver's license improves the collection of arrears for persons making less than 300% of the federal poverty level, or $39,000 a year. However, Maryland continues the practice of suspending lower income obligors in supposed compliance with federal law. I could go on, but I want to hear from our panelists, and I want to also suggest that I've had some conversations with various stakeholders, and while my original bill calls for simply ending child support, ending driver's license suspensions altogether for child support arrearages, one of the witnesses is going to testify that there is a belief that we could just simply put an income boundary in this bill that would have us comply with federal law. And then there's another witness that will testify that we might want to do another amendment that would eliminate automated driver's license suspensions, which I am 100% in favor of. I'm saying all of that to say that I'm amenable to working whatever is the best scenario, but the goal is to stop suspending people's licenses because they owe child support and thus prohibiting them from being able to work and be productive and pay child support. So that is my testimony. I'm happy to answer any questions and looking forward to hearing from the witnesses. Thank you.
Thank you, Senator Carter. And so we have your primary witness for Senate Bill 402 is Mr. Hatcher. So we'll go to Mr. Hatcher first. Mr. Hatcher, because you're the primary witness, you have 5 minutes.
Thank you. Everybody hear me okay? Great. Thank you to Senator Carter and to the whole committee. Again, my name is Daniel Hatcher. I'm a law professor at the University of Baltimore, where I teach primarily in the clinic where students learn by representing low-income clients. I've advocated for and written about and engaged in scholarship regarding poverty and low-income individuals for about 25 years now. Child support has been a substantial part of my work. Back when I was a legal aid lawyer, through when I was at the Children's Defense Fund and continuing now, including my last book, The Poverty Industry. So I applaud this effort and this legislation. It's very important. And I want to stress from the beginning that this type of legislation would lead to very likely an increase in child support payments, right? Not an increase, not a decrease. So the reasons for that are that so many vast numbers of low-income obligors in Maryland and around the country are negatively impacted by license suspensions and are unable to get their licenses reinstated. All the numbers that I've seen through my research data, I've seen from various child support agencies who have put forth numbers to show the amount of payments that are connected to license suspensions, right? Those don't separate out all the other enforcement mechanisms. So even though they list payments along with license suspensions, those are in cases where there are more effective techniques such as tax intercepts, wage garnishments, and the like. So in these cases, child support payments are happening despite the suspensions, not because the suspensions. I hope that makes sense. So also, as Senator Carter pointed out with the federal legislation and the requirements there, if there was an amendment in place here, instead of outright repealing the entire suspension program, that there was a cap or a trigger, if you will. I think what's currently being discussed is 300% of the poverty level. I believe this would be in compliance with federal legislation. All the federal legislation requires in U.S. Code Section 666, the subpart is that states must have procedures under which the state has and uses in appropriate cases, right? A process that gives it the authority to withhold, to suspend licenses. So that language in appropriate cases gives wide leeway to states to determine what's best for the population, right? And this means what's best for the custodial parents, the non-custodial parents, the children, and all of us. So again, by having this cap or trigger, right, it would be better for all of us. I mean, if I had more time, I could go case after case after case and how many examples I've seen where license suspensions have harmed the non-custodial parents, the custodial parents, and the children. Part of the problem, and then I'll stop, I'm probably almost out of time, is that huge percentages, huge numbers of low-income obligors, right, which is almost the entire caseload of the 4D system, right, start out their orders with arrearages, right? And that's because the way this works, once a court finally enters a child support order, it's retroactive to the time of filing, right? By the time it works through the court system, that can be multiple months, sometimes 6 months, sometimes even more when I was doing these cases in Baltimore City, right? So right off the bat, before an obligor even has a court order to pay, they're often multiple months behind in their child support order, right, from day one, which leads to an automatic triggering of the license suspension. So they never have a chance to start with. So again, I applaud this effort. I'd be happy to field any questions on specific, legislative or otherwise, but this would absolutely cause an increase in child support payments and a reduction in harm for everybody involved, including all of us. Thank you.
Excellent. Thank you very much. So next, we'll move. I'm just going to go in order, Senator Carter. So, Ms. DeFore, you're up next.
Yes, good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. Again, for the record, my name is Christine Dufour. I'm a supervising attorney with the Office of the Public Defender. I'm currently in Talbot County. I don't know if many of you know that back in the mid-90s, I worked for Delegate Mark Shriver out of Montgomery County District 15 when this legislation was contemplated, and Mark, a good friend, and he knows I would testify this way today, thought like many other legislators across the country that how can we get people to pay their child support? Bingo, we need to incentivize them, take away their driver's license. That's one thing when you're in a population where you have access perhaps to metro and buses and cabs, Where I am now in beautiful Talbot County, with my senator being Senator Eckert, my clients routinely continue to drive because they have no way else to get to their painting job or their farm job. And it becomes a very cycle of poverty, cycle of in and out of the courts, in and out of MVA. And I will say it's been my experience where someone has actually righted the wrong, paid child support, and MVA doesn't even get the information and he's still suspended. I literally told a client once, ride around with your letter from child support that you're in good standing to show the police. So for a myriad of reasons, I know JRA and this body did a big help in making failing to pay child support part of the 16303H provision, which is a $500 fine only, not a year in jail. But if you continue to drive because you're trying to get to work, unfortunately, you can rack up 3 points and 3 points and ultimately end up suspended for a point violation. So I think the goal is to incentivize payment of child support, like the professor wisely said, in other ways, as opposed to taking away the license. And with that, I'll let Mark know again that I testified to take away the law that he helped support.
Excellent. Thank you very much. And with that, we'll have Mr. Harper. You are up next. Is Mr. Harper here? Okay. Okay. Ms. Bensky, you're up next.
Sure, thank you. So thank you for having me testify today, and a special thanks to Senator Carter for the invitation. My name is Stacey Bensky. I'm an attorney with Maryland Legal Aid, and I work with family law clients with child support issues. The automated system used by the Child Support Enforcement Agency to suspend driver's licenses disproportionately affects those who are living in poverty. So Section 10-119 of the Family Law article bars license suspension for obligors with a documented disability. Section 10-119 also bars license suspensions for obligors who are paying on their arrears per an agreement or court order. Despite this, Maryland Legal Aid clients who pay every month towards their arrears through earnings withholding orders and clients who receive disability benefits as their only form of income are routinely referred to the MVA for license suspension. This happens because the agency's automatic license suspension system operates as if those exceptions in the statute do not exist. The license suspension system is an automatic and random lottery. So all obligors with 2 months or more of arrears are automatically in the pool of people who can be chosen at random each month to be referred to the MVA for license suspension, regardless of whether they fall under an exception. So for example, my client who's 62 years old and worked most of his life at Bethlehem Steel until he became disabled. Despite paying his child support as best he could, he does still owe arrears from decades ago for his now adult children. His disability benefits are garnished every month to pay off his arrears through earnings withholding order. So he falls under that exception in 10-119, yet he is continually referred to the MVA for license suspension. So each time I have his license reinstated, a few months later, he receives another suspension notice. Like most of my clients, the agency does not have the authority to suspend his driver's license. But because of their automatic system, until his arrearage balance falls below 2 months worth of arrears, he will perpetually be in that pool of people. This client also helps his adult children by caring for his grandchildren. And because he's disabled, he has a lot of health issues, he has frequent doctor's appointments. These everyday activities become difficult when his license is suspended. Many Maryland Legal Aid clients have unstable homes and therefore unstable mailing addresses. So they never actually receive the suspension notice before their license is suspended. So they don't know their license is suspended until they're pulled over. A routine traffic stop then becomes a criminal charge for driving on a suspended license.
Time.
Okay, can I say one last sentence?
Absolutely. You can briefly conclude, yes.
Okay, sorry, just that charge, driving on a suspended license, is not expungible under Maryland law, and then locks in previous charges that otherwise would have been expungible. And that creates yet another barrier to employment. And that was my last point. I do believe that this law would have lasting positive impacts on not just obligors, but families and marginalized communities as a whole. And for these reasons, request a favorable report. And I thank you so much for your time and consideration of my testimony today.
Excellent. Thank you very much. So now we will move down to Mr. Dews. I think I saw you. There you are. You're up
There
next.
I am. Good afternoon. Good evening now, members of the committee. My name is Christopher Dews, once again for the record, and I am a policy advocate for the Job Opportunities Task Force, in which we have a pre-apprenticeship training program where we take Baltimore City residents and we try to get them into full-time employment, basically doing carpentry, plumbing, and electrical work. We train them for about 14 weeks. And one of the biggest barriers that we see to employment that is just strong and prevailing is transportation. It's the opportunity to be able to drive. The vast majority of employers that we work with within the city require a driver's license, a valid driver's license to be able to be employed. And so actually, Mr. Charles Harper is a colleague of mine, and I think he's having some technical difficulties. He might be logging in right now to try to testify, so he can speak more clearly to this. But the bottom line is the vast majority of the trainees that we've worked with, interviewed, tried to bring in, the biggest barrier has been their licenses. They are not able to go to work, and if they're not able to go to work, they are not able to provide for their children. They're not able to provide and pay back the child support. So the current law, as it is in place, prevents people very strongly from being able to provide child support for their actual families. And what we also discovered when we were doing our research on this is that the vast majority of people that are actually child support obligors have direct relationships with the custodial parents. The only issue is that the child support system had to be involved for the sake of securing benefits. And when we did some research as to the custodial parents, whether or not the custodial parent would want their non-custodial parents' license to be suspended, the answer was a strong no. Because if the license is suspended, then that means that the custodial parent, the non-custodial parent cannot pick up the kid from school, cannot take them out on weekends, cannot feed them, cannot go on trips, cannot go on events, cannot visit school visits. It actually complicates the entire thing. Also, doubling down on that, I believe it was already mentioned that Transportation Code 16-303 acknowledges that a person who drives with a suspended license can risk incarceration, or I believe it's up to a $1,000 fine, or both. And so what we have here is lower income people who are trying to get to work, who may have child support orders that they cannot pay for, are finding themselves, one, out of employment, stopped totally from ever even having the chance to get a job, and then totally locked down from being able to live their lives. And so for those reasons, what we would like to see specifically to comply with the federal law 666, which is interesting in and of itself, what we would like to see is an amendment for 300% the federal poverty line, which is $38,000, roughly $38,640. For those who make that amount of money and below, that suspensions are not required for those who cannot pay child support because they simply do not have the ability to pay, and suspensions will ruin their economic opportunities and just generally ruin relationships with the families. And so for those reasons, we urge a favorable report with slight amendments for that 300%. We thank you for your time, and I thank you to all the members of the committee for listening. Thank you.
Excellent. Thank you very much. And with that, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and it's Ms. Fleming. There you are. And then we'll go to Senator West. I saw you there.
Thank you, Chairman. I appreciate the opportunity to be here today, and I really appreciate the opportunity to hear all of the speakers who spoke in favor of this. I feel like I live in a different child support world, and my organization does. I am here on behalf of the Family and Juvenile Law Section Council of the MSBA. We are comprised of mainly private family law attorneys, and I spend a considerable amount of my time chasing child support, trying to get child support from people who absolutely do not fall within the income brackets that you all have been discussing. They are instead people who can and should be paying child support and do not. And so we live in this, we are just as frustrated on the other end, looking at people who we are trying to enforce child support orders against. And we feel that this is one of the few tools that we have. The people who fall within the income brackets that my colleagues and I deal with would not have any kind of an issue in terms of finding the resources to prevent this from happening to them. I'll be frank, we are frequently going to child support enforcement and saying, why aren't you suspending this person's license? And they say to us, well, you know, they're making payments. We get $10 a month on a $2,000 obligation. So as long as we're getting payments, we're not going to suspend their license. So I think there is a huge disconnect in terms of when this is being utilized, because I feel like I can't get it used in most instances when it should. And we're trying to have this used against someone. And the people who I'm dealing with who aren't paying child support, they kind of know the system. They call child support. What do I have to do to avoid getting my license suspended? Oh, just make sure you send this amount of money on a monthly basis and then we won't come after you. So we're coming from the opposite perspective. We don't want to lose one of the very few enforcement tools that we have. But as I said in my written testimony, we are aware that this is a problem, that it is being disproportionately utilized against low income payors, and we don't like seeing that either. And we would really be in favor of any kind of an amendment that would keep this law in place so that it can be used against the people it should be used against and would not be used in an inappropriate manner. And it sounds as if it has been, and we're not blind to that and we don't discount it at all. We just desperately don't want to lose one of the few enforcement tools we have. I'm constantly telling my clients when we get child support orders, sometimes we wait months or years for that, and they express relief to me, and I say to them, well, you know, this is really just a piece of paper signed by a judge that says you're going to get money, and it might be a lot more difficult to turn this into dollars that hits your account on a monthly basis to help you to support your children. So my organization is not want to see this repealed, but we would very much like to see something that would protect the disproportionate implementation of this law so that it can be used in an appropriate manner against the people that it should be used against.
Excellent. Thank you, Ms. Fleming. All right, so now I saw Senator Carter, this is your bill, so you go first, and then Senator West.
Thank you, Mr. Chairman. Ms. Turnbull, just two quick things. One, so I think you cleared that up, that you could support the bill if the amendment that was proposed that dealt strictly with people that under a certain level of income or at the poverty line, federal recognized poverty line, were the targets, or were the ones that were, I should say, not the targets, but actually given some relief under this bill. But the second thing that I wanted to kind of explore, it reminds me the opposite end of what Ms. Bensky from Legal Aid was explaining to me. You know, if there are in fact affluent obligors that are not paying, and child support is not, you know, bringing down the hammer in every way that it can, yet by the same time, Ms. Bensky has clients that are disabled but have no money at all, and they're having the hammer brought down. It sounds to me like there's a serious problem within the Child Support Enforcement Bureau. And I am wondering if you, because of your experience, if you can speak to that and what might be done to fix that.
That is a very interesting question because, like I said, we sometimes reach out to child support enforcement ourselves, or we tell our clients to, because, you know, I see people who should be paying and they said, oh, I'm not going to work. And they're literally flying to St. Martin in their, you know, the home that they have there, but I can't get any child support for my clients' kids. And I think that it's easy for some people to figure out how to play this system, where if you reach out to child support enforcement instead of waiting for them to come for you, that they'll work with you in terms of telling you what you need to do. I also have been to many hearings in front of magistrates where people are pulled in regularly by child support enforcement to make payments. And the judge says to them, all right, next time you come, you better have some money or bring your toothbrush. And so then the next time they come, they show up with, you know, $150, even though they owe $20,000. And the judge says, okay, come back again, another couple of months, bring some money or a toothbrush. And this obligation just continues to grow and continues to grow. and people just sit back because there's really nothing that the court can do to them, that they perceive there's nothing the court can do. So there's really not a lot of enforcement options. And even though, I look at this statute and I think, why are these not going out all the time? Why is Ms. Bensky having people who cannot afford it and are saying, I'm on disability, why can't I get rid of this? Why is that person not able to get rid of the enforcement? And my colleagues and I are wondering why we can't get any kind of enforcement to come down on people who should be working. I mean, you talk about people who want to work and can't, and I'm looking at people who can work and won't. And it seems to me that we actually need more enforcement tools against those who have the ability to pay or won't, or have the ability to get a job and pay and won't, instead of, it looks to me that all of the focus is on the people who don't have the ability to pay.
I think that's the
I think
majority.
I said in my testimony, I got a little dramatic that this is a travesty when I try to, get some money for, these single moms or single dads who are raising these kids by themselves and they can't get any support.
I think the majority is probably the people that have little to no ability to pay this extreme arrearages that accrues or that can accrue. But to me, it sounds to me like from what you're saying and from what I'm able to ascertain that it's not just a matter of more enforcement tools or less. It sounds to me like the Bureau of Support Enforcement has real low accountability. And that's a problem. I don't really have a question other than that. Thank you for your testimony.
Thank you.
Excellent. Thank you, Senator Carter. I did get noted. So Mr. Harper logged in a little late, but he's here, or I didn't see him. So Mr. Harper, you were signed up, and let's hear your testimony. We'll continue on with questions from the panel. I think Senator West is next, but Mr. Harper, you're up.
Good afternoon, everyone. My name is Charles Harper. I am a case manager for the Job Opportunities.
I'm sorry, Mr. Harper, are you ready to go? Is that it? All right, we'll just keep moving. Let's go on to Senator West. You're up. You've got your question.
Yes, thank you, Mr. Chair. So I have three reactions. One of them is a question. The first is, when we did the last bill, my conclusion was we ought to have a summer study on the enforcement of child support to try to get the stakeholders together and figure out how we can put a better system together that works better. That feeling is reinforced by this bill. Again, we've got problems with enforcing these orders. And we ought to get the people together who can come up with creative ideas. One idea I had was ankle bracelets, which would track people around in an order saying that you have to live in your house, you can go to the supermarket or the drugstore, and you can go to work, period. With ankle bracelets, at least these days, we could track people and enforce that kind of an order. So just an idea. Secondly, I noticed that both the Judicial Conference and the Attorney General cite a section of the Social Security Act, and they say if we're not careful here, the state of Maryland can lose a lot of money from the federal government. So whatever we do, we need to be very careful not to violate the Social Security Act and forfeit that money. And finally, my question: the last bill, there was seemed to be nothing there except putting someone in jail. In this one, though, and nobody's commented on it, I don't know why. The part of the statute that the bill tries to change specifically says, upon notification by the administration under the subsection, the Motor Vehicle Administration, 1, shall suspend the obligor's license or privilege to drive in the state, and 2, may issue a work-restricted license or work-restricted privilege to drive in the state. I don't know what exactly the details of a work-restricted license or work-restricted privilege are. I think I can figure it out just in common sense basis. That seems to me maybe that would work. You don't let somebody drive recreationally. If the person wants to drive to the job and then come home after he finishes his job, that's okay. You get a work-restricted license. If that is the case, if I'm right as to what a work-restricted license is all about, why isn't the current statute okay?
All right, who would you like to respond to that, Senator West?
I guess anybody who wants to. How about Mr. Dews?
Yes. Okay. First of all, I want to thank you for that question, Senator West. I do want to say the problem with the work restricted licenses, actually it's in the name, is that it's a work restricted license. Senator Carter already mentioned that 62% of Marylanders who owe child support make less than the minimum wage and owe at least $10,000 in unpaid arrearages, and that they will never be able to pay off this debt. So the reason why that's important is because at that point, you're going to have somebody locked down for quite a while. And the thing with work restricted licenses is the fact that, as it says, it's only work restricted, but the vast majority of cases that we've seen with people who are under child support right now, it's not, the idea in the past was about deadbeat dads. And as more research was done, it's actually more about dead broke parents in general. So as Charles Harper was going to testify, his audio kept going in and out. He just sent me a message about that. But he's going to testify of the fact that, like, these are people that are actively taking care of their children, right? They're taking them to the beach. They're taking them to school. They're dropping them off. The problem with us making the license work restricted is that you are now going back to harming relationships with the family, because now the individual cannot spend time or actually work deals out with the custodial parent, which is already happening. So work restricted, it doesn't actually do enough to basically ensure that money is still going back to the family, but also that the family unit stays together, which is the overall purpose of the child support program. Hope that answers the question.
If I could, let me turn to Ms. Turnbull. You seem to talk about a number of parents who are deadbeat parents. I mean, Mr. Dews says the more of them are broke, but you say there are an awful lot of them who are deadbeats. Wouldn't a work restricted license, where the only thing the person can do on a day-to-day basis is go to his job, do the work, and return home again? Wouldn't that help to? Are these work restricted licenses used by the courts? And
No.
if they are, do they assist in getting the deadbeat dads to pay up? Oh, she's
Senator West. You want? I see Ms. Bensky wants to get in. Do you?
Oh.
You want to go ahead and just, if it's responsive to that, I see your hand. So.
Yeah, I do. If that's okay, I do have a response. Yeah, I've been doing this work since the end of 2018 was when Maryland Legal Aid started taking these cases within our regular family law practice. I have never seen that happen. I've never seen that part of the bill ever. So what happens is the MVA doesn't have any discretion. Like, they will want nothing to, they don't have discretion in the transportation article of the law, but also they just will say, just deal with the child support agency. At least for my clients who, as I said, are, if they're legal aid clients, they're below the poverty level. The agency, particularly in Baltimore City, because that's primarily where I work, but all around the state, they're not going to work with the non-custodial parents, obligors, at all. So what, in my experience, where I've had clients who have actual, I'll forward emails, they'll have notices from potential employers who have said, whether it's a trucking job, or I had one client where he's the manager of his local Pizza Hut, was willing to write him a letter that said, I will hire him to deliver pizzas, but I need him to have his license first. Like, they're not a desirable job candidate if they don't have their license, right? And I gave all of that documentation to the child support agency in Baltimore City. They still refuse to reinstate his license. And if they're not going to give the license and give you even work restricted, the MVA really has no authority to do it. It comes down to the child support agency, and they will fight tooth and nail because of the connotation that Chris Dews brought up about the deadbeat dad, where in my experience, and again, because I'm working with low income families, and I say families, not just dads and obligors, because I approach every case with a family centric idea to it. And of course, with my client's permission, I am almost always in touch with the custodial parent as well. And I've never come across a custodial parent who has wanted the non-custodial parent's license to be suspended. Because not only is it that they can't get to work or they can't get to job interviews, but also they can't spend time with their kids.
Let me just interrupt if I could. I wanted to try to get back on point. I was trying to talk about these work restricted license. So your testimony is, in your experience, the MVA never issues a work restricted license.
I've never seen it.
Okay, Ms. Turnbull, what is your take on this? you're opposed to this bill. What about the work restricted license aspect of it? I'm sorry, she's still muted.
All right, Senator West, do you want Mr. Hatcher to respond?
No, I really wanted Becky Fleming Turnbull from the State Bar Association.
There you go.
Had opposed the bill.
Sorry for the confusion. It's just Fleming. Turnbull is part of my firm name.
Oh, I'm sorry.
That's okay. I've never had a client call me and tell me that that child support enforcement is threatening to restrict their license. And I've never seen a client call child support. My clients are calling child support enforcement if they're trying to get money and they're saying, why don't you take away my ex's license? So I have the opposite experience of Ms. Bensky. My clients who are looking to get support would want that pressure to be put on their ex, but child support enforcement frequently won't do it at their request. And I've never heard of child support enforcement threatening to modify the license so that it would only be a work license or something like that. I've never seen that happen.
Okay.
I mean, I read the statute right before I drafted my testimony. I kind of thought in my head, oh, I didn't even know that existed. I've never heard of them doing that. And I've been doing this for over 20 years.
Thanks.
All right, excellent. Thank you, Senator West. Looking around the room for additional questions. Seeing none, we will now, all right, so that'll end the testimony and the hearing for Senate Bill 402. We'll now toggle back to Senate Bill 401. Senator Carter, you're up.
Thank you, committee, for your indulgence and your endurance. And thank you, Mr. Chair. So switching subjects just a little bit off of child support onto how we can help people and families across our state stay in their homes and help prevent homelessness to some extent. Senate Bill 401 extends the amount of notice a landlord is required to give a tenant before not renewing their lease, giving the tenant more time to find housing. The reason for this bill is simple. It would fix a loophole that has been brought to light because of the COVID-19 pandemic. While evictions may be halted by executive order or legislative act, landlords can circumvent these acts by simply allowing an individual's lease to expire without reason. Because this is a tool for landlords to avoid any eviction stays, the tenants should at least be awarded reasonable notice of their lease's non-renewal. The bill mandates varying notification lengths depending on the length of the previous tenancy, type of lease, and type of residence. For example, under the bill, a landlord will be required to provide notice to tenants who hold an annual lease at least 3 months in advance. For tenants with a month-to-month lease who have been in their home for more than 2 years, the landlord would have to provide notice of at least 2 months. And for week-to-week leases, the landlord would have to give notice at least 1 week in advance. In addition to closing this loophole in the current law, the bill can be a benefit to both landlords and tenants. For landlords, the time period between the notice and the lease termination can give them the opportunity to fill the vacancy. Therefore, the tenants will not have any lag time. The landlords will not have lag time between tenants. More importantly, this bill will benefit the tenants by giving them ample time to find new housing and help them avoid homelessness. Last, the state would not be fiscally burdened given the notice requirements in this bill, as according to the fiscal note, there is no material effect on state operations or finances. The last thing Maryland needs now is more citizens living in the streets, especially during the current pandemic. This bill would offer tenants slightly more time to figure out their living situation before facing homelessness. The changes proposed here are straightforward. The bill will bring Maryland in line with the laws of other states. Several states have already require a longer notification for a landlord's lease non-renewal, including a 60-day requirement in Delaware, Georgia, and Vermont. If landlords are not going to renew leases of vulnerable tenants, the very least they can do is give them fair warning, because no Marylander should be thrown into homelessness with little to no notice. Finally, I will say, Another benefit to this bill would be the uniformity and parity amongst all jurisdictions in the state, because currently these notice requirements fluctuate from jurisdiction to jurisdiction. Thank you for your time. I'm happy to listen to the panel and take any questions. Thank you.
Thank you, Senator Carter. So I have Ms. Hatfield as your primary witness. So Ms. Hatfield, you will have 5 minutes. Good to see you again. The floor is yours.
Good to see you again, Mr. Chair. Good afternoon, Mr. Chair, Mr. Vice Chairman, and members of the committee. Thank you for the opportunity to be here today and speak on this very important legislation. And thank you to Senator Carter for putting forth this important bill that is being heard before you today. As stated, my name is Carissa Hatfield, and I am a housing staff attorney with the Homeless Persons Representation Project. We are a civil legal services nonprofit, which has offices in Baltimore City and Montgomery County, Maryland, though we serve clients all over the state. Our housing division represents tenants in failure to pay rent, tenant holding over, and breach of lease matters in an effort to execute our mission of preventing and ending homelessness. Senate Bill 401 seeks to modify the current law regarding tenant holding over matters in regard to tenants in month-to-month tenancies. Under the current law, a landlord is only required to give a tenant in month-to-month tenancy 30 days notice to vacate the premises. And this is regardless of how long the tenant has lived in the property. Providing only 30 days notice to a tenant who's resided in their home for a period of 5, 10, 20, or more years creates significant difficulties in finding and maintaining stable housing. And my colleagues, Mr. Countess and Mr. Shaw, will outline some of these challenges in their testimony. This is particularly true at this time in our history when a global pandemic rages across the state and across the country. Many tenants have been unable to pay their rent due to COVID-19 related income loss, and non-payment of rent matters have been delayed in the courts. As a result of this perfect storm, tenant holding over statute has recently been used as a workaround to evict tenants who have fallen behind on their rent due to the public emergency. The Baltimore Sun noted in a December 2020 article that in August and September of 2020, there was an 82% increase in tenant holding over cases filed compared to the same time period in 2019. SB 401 seeks to give more time to month-to-month tenants whose landlords wish to end their tenancy and creates a stair-stepped notice requirement. For tenants who have lived in their home for 2 or fewer years, it would require that the landlord give 60 days notice instead of 30 days notice. For tenants who have resided in their homes for 2 or more years, it would require 90 days notice instead of 30 days notice. I want to tell you a story now about a client of HPRP that helps illustrate why Senate Bill 401 is so important. Rebecca was a client of ours. She's a 58-year-old mother and grandmother. She's permanently disabled, and her only current income is Social Security disability income, which is less than $1,000 per month. She's been a participant in the Section 8 voucher program since the early 90s. In 1995, Rebecca found a single-family row home that was a perfect fit for her and her 2 young children. She moved in that year and raised her 2 children there until they reached adulthood and moved out, having families of their own. Rebecca found medical providers in her community and had been seeing them for many years and became dependent on their care. She found support networks in her neighbors and helped to care for her homebound elderly neighbors, even getting groceries for them and making sure their homes were maintained despite her own struggles with her medical issues. In January of 2020, Rebecca's landlord sold her property to a new landlord who, after inspecting the property, believed that the home should be repaired to the point of where Rebecca would have to move out. After 25 years of residing in her property, Rebecca had very little time to try and locate somewhere new to live where she would be both close to her medical providers and her community network of support. Having 90 days to relocate, and have new housing would greatly assist clients like Rebecca in maintaining stable housing. And I'd like to emphasize that this is particularly true in light of what we're going through right now. The opportunity to have more time to maintain stable housing during a global pandemic is necessary to prevent and end homelessness. HPRP strongly supports Senate Bill 401 and urges a favorable report. I thank the committee for its time today, and I will yield my time. Thank you.
Excellent. Thank you very much. And next, we will have Mr. Shaw. Mr. Shaw, you're up next.
All right, thank you, Chairman Smith, Vice Chair Waldstreicher, members of the committee. My name is Zephyr Shaw. I'm an attorney at the Public Justice Center and our Human Right to Housing project. First, just want to thank Senator Carter for sponsoring this legislation. This measure is going to greatly assist the over 700 renters across Maryland that we serve with legal assistance, including brief advice and representation. Our clients know firsthand the upheaval of facing lease termination on short notice. So we urge a favorable report on SB 401. I want to emphasize that this bill is of particular importance to families in month-to-month tenancies. For them, notice really is everything. 30 days, which is their current requirement for a notice of non-renewal, is a dauntingly short amount of time to pick up and leave. Particularly when you have kids that are rooted in a community. This inordinate challenge also extends to low-wage workers and elders and people with disabilities. And I want to be clear, this is not a just cause bill. This doesn't remove the prospect of a sudden no-fault lease termination, but it does strengthen housing stability by ensuring across all Maryland jurisdictions that renters would have a minimum 60 days notice to leave. Going back to the pandemic, this is not a pandemic bill, but I want to talk about the urgency for this bill. Amid the opening of this pandemic, my client's school closed. She was a pre-K teacher. She's 67 years old and lived in her property, living paycheck to paycheck and month to month for 17 years. And at that time, she told us at PJC, I don't have internet in my house. I'm not good with computers. I've gotten some advice about applying for food stamps and unemployment insurance, but it's going to take a while. In the meantime, I haven't had any income coming in for the past month, and I don't know if I will. The landlord just sent me a notice to vacate. And so we think back to this time of the state trying to stand up emergency unemployment, stand up rental assistance programs, energy assistance, and time was not on the side of countless households in Maryland. And the fact that a landlord could threaten to dispossess a person in that time of urgency, just on 30 days notice, I think brings home the point that we need to give people more time. And it's not going to always be a pandemic, obviously. It's going to be that calamity strikes with a sudden illness, an injury, a death in the family, loss of public benefits. 60 to 90 days notice under this bill doesn't cure every problem, but it cures a lot of the economic pressure that Maryland renters are currently faced under a 30-day policy. So we urge the changes in this bill and a favorable report on SB 401. Thank you.
I believe next up we have Mr. Contes.
Thank you. Thank you very much, Mr. Chair, Vice Chair, members of the committee. My name is Gregory Countess. I'm an attorney with Maryland Legal Aid. I'd like to thank you for the opportunity to testify here today, and also to thank Senator Carter for introducing this particular bill, which is an important step in advancing Maryland toward the human right to housing. It's no secret that there was an affordable housing crisis before this pandemic. There'll be one after this pandemic. Just to give you some numbers, approximately 278,000 families in Maryland, renters, spend more than 30% of their income for rent. Of those, 147,470 of those families pay more than 50% of their income in rent. And these statistics just reflect what we at Maryland Legal Aid have been told by our clients, and that is that affordable housing is their number one problem and issue. So the change from 30 days to 60 days notice for a month-to-month tenant is an important step because it provides something that these renters don't have when their end of term occurs, and that is time. Time for them to make arrangements to move, time for them to be able to gather the money and resources to pay new security deposits, to pay a first month's rent, and even to pay to move and to make changes and connections for gas and electric and whatnot. This time is the difference between being housed and being homeless. The fact is that, it was a recent report from the Federal Reserve that shows, in fact, that families cannot even afford a $400 debt. And so with that in the background, and the fact that this is a bill that will help to ensure that folks get more time, though it may not address their primary concern, which is affordability, it will give them time to attempt to connect with resources that may assist them in being able to be housed. And with that, thank you. And with that, Legal Aid asked for a favorable report on this bill. And thank you for the opportunity.
Thank you for your testimony. Are there any other witnesses on this bill? Seeing none, that concludes the testimony. Are there any questions? Seeing none, that concludes the bill hearing on Senate Bill 401. Thank you to the panel. I appreciate all of your testimony. We will now move to the next bill on the agenda. Senator Sidnor, are you ready? Oh, wait, I see Senator West now. Where were you? Senator West?
Sorry, I was waving my hand, but I turned my camera off. So
I'll do it.
So as I understand it, on the bill that we just concluded, and I hate to come at the end, if someone has been living on a year-to-year tenancy, which most tenants are, I understand, then there would have to be 3 months notice of an intent to evict, correct?
Yes.
Okay, so in order to, if I'm a landlord, to protect myself, would I be able to give notice in January of an intent to evict in May? That's 3 months notice, maybe April, whatever. So that if the tenant doesn't pay in April, I've given the notice in January that for failure to pay, I'm going to evict in April. Or do I have to wait until April and then give them 3 more months to live in the place free of charge before I can start eviction proceedings?
So this isn't a failure to pay bill. It's about non-renewal. So it's like when at the point when the lease is not going to be renewed for, it could be a myriad of reasons. It doesn't have to be limited to failure to pay.
I'm sorry. Yeah, okay.
Well, the end of the term. So this is just so that like a person isn't caught off guard with a very short notice that they've got to go. That is really just to extend that notice, but I'll let anybody else on the panel speak.
I think it makes an awful lot of sense in terms, if it's just relating to non-renewal of leases. If it's related to failure to pay, then I think it's more complicated. I'm sorry, my attention was diverted and I didn't get a chance to read the whole bill carefully myself. So maybe I'm barking up the wrong tree here.
No problem. We're doing a lot.
Yes, we are.
Any other questions, Senator?
No, that's it.
All right, thank you so much. That concludes that bill hearing. And so next we have Senator Sidnor with Senate Bill 454. There you go.
Yep. So regarding Senate Bill 454, good afternoon, almost good evening to everyone. The landlord-tenant relationship rests on some competing interests that we've had an opportunity to listen to this past interim. On the one hand, the property owner has an interest in property as an investment vehicle and a source of income. On the other hand, the tenant has an interest in a place to live. Our rent courts are set up with respect to both of those competing interests when a tenant is delinquent on rent. As to landlords, the district court allows landlords to file and complete eviction actions quickly and efficiently so as to protect their investments. The district court allows tenants opportunities to object to repossession actions, but in practice, an overwhelming number of tenants are unable to protect themselves from ejectment due to limits on time, knowledge, and resources. And just as a personal aside, when I was in law school, landlord-tenant court was one of my first places to actually be in court. And I'll tell you, for someone who is not a repeat player and who shows up in court consistently, even for a law student, it was quite overwhelming. Senate Bill 454 will transform the summary repossession process in three fundamental ways. One, it will ensure tenants are made aware of their rights well before showing up in the courthouse. Two, it will require landlords to treat their tenants as equal parties to an agreement rather than as just some sort of issue to be solved. And three, it will ensure tenants in need of assistance before trial and that pretrial hearings will have assistance. Landlords will no longer be able to use a summons to district court as a final notice to tenants on delinquent on rent. Moreover, Senate Bill 454 will do nothing to take away a landlord's substantive rights. It will simply guarantee true due process for tenants. This eviction diversion program under this bill is dedicated to promote continuity of housing by reducing the incidence of evictions. The program will engage eviction prevention service providers to screen tenants in need of assistance. And if I might point out, this is a bill that would only affect, according to the fiscal note, page 610 of Maryland's 24 jurisdictions where this program would be established, with the other jurisdictions there being a may, and if they would want this type of program, they could establish. My home jurisdictions are with Baltimore County is number 1 in the claims for repossession, with Baltimore City being number 2. With that said, I would like to turn my testimony over to my esteemed panel. I would ask for a favorable, and with that, our lead proponent is Mr. Shaw from Public Justice. After Mr. Shaw testifies, we'd like to have former Judge Andre Davis testify, and thereafter Christopher Merriam. So with that, I do thank you.
Thank you, Senator Sidnor. Mr. Shaw, you're up. Hopefully unmuted soon. There you go. Can't hear you.
Sorry, many thank yous were said to Senator Carter and to Senator Sidnor for sponsoring this bill, and to members of the committee for having my testimony today. I'm Zafar Shah, attorney in the Human Right to Housing Project at Public Justice Center, and we urge a favorable report on Senate Bill 454 because this bill moves us finally from rapid adjudications that accelerate housing instability to a more equitable process in eviction courts, one that is predicated on, first, eviction diversion, meaning engagement in alternative resolutions that avoid judgment or litigation altogether, and 2, effective pretrial opportunities to be heard. So starting out with what we know about the legal process for failure to pay rent cases is that the process has no preconditions up front. There's no waiting time after the rent is late, no notice of delinquency, no steps to avoid litigation through a repayment plan or mediation, or even to an application to obtain rental assistance. These are simply not requirements at the outset. And furthermore, we know that the court process is tilted against defendants. A 2015 study by Public Justice Center found that 60% of renters who came to court to contest their failure to pay rent case had a legal defense based on defects reported to their landlord before trial. And barely 1/3 raised the issue with a judge, and only 8% succeeded with their defense. And this 92% failure wasn't surprising given that the majority of the renters had no knowledge of their defenses. And additionally, they had no grounds for a recess or continuance to seek or utilize legal assistance. There was no pretrial opportunity to raise a defense and no access to records that will be used against them at trial. And so SB 454 tackles these long-term problems, and it brings about the three fundamental changes that Senator Sidnor mentioned. It creates a precondition to filing, and that's by a 10-day notice of delinquency and legal rights. And it's more than just a notice, it's 10 days in which the landlord must take affirmative good faith steps to work with the tenant to apply for rental assistance, and if that's not possible, to utilize a repayment plan. Importantly, if a tenant doesn't respond, then that 10-day step is fulfilled and the landlord can go ahead and file their action. However, if communication is underway, the efforts are pending, then the parties must see those efforts through. If a failure to pay rent case is filed, then under the bill, there's a status conference instead of an immediate trial date. And this is where litigants request to engage with an eviction diversion resource at the court if it's available, and where judges can order referral of the parties to mediation, where either party can seek a continuance to obtain counsel, and most importantly, where a renter has that formal opportunity to raise a defense or a counterclaim. And the court schedules a trial date a few days later, not more than 10, if the judge deems the defense or counterclaim meritorious. And then the judge may also, on that basis, order the parties to share documents that will be used at trial. And importantly, if the tenant fails to appear at the status conference, the court may enter a default judgment, just as happens in 95% of failure to pay rent cases historically. These pre-filing and pre-trial procedures are uniform across all jurisdictions, but the bill establishes the eviction diversion programs just in the jurisdictions with 10,000 or more eviction cases. And that means that the judiciary is obligated in 10 jurisdictions by the fiscal note count to facilitate provision of services at court when a tenant wants to avail themselves to those services. The obligation is not to screen each and every tenant in 670,000 cases, but rather to afford the 3 to 4% of defendants that appear at court the opportunity at the status conference to engage with available service providers. And finally, SB 454 maintains the summary aspect of the action. The timelines set forth in the bill are modest changes. We know that there's additional delay, but we don't think it's too much to ask. This bill still provides landlords a tool for debt collection and repossession of property that works faster than any other civil action. And overall, these pre-filing and pre-trial changes aren't unheard of. For instance, Virginia enacted an eviction diversion program in 2018, and recently they also enacted an extension of their pre-filing notice from 5 to 14 days. And now they also require landlords to offer renters the option of entering a payment plan with no late fees before the landlord can file an eviction. Good interventions do occur at the district court in the best cases where landlords are invested or the judge has the time. And SB 454 is about ensuring that we have that best case scenario in every contested case. Mediators, social workers, legal service providers, public health experts, and even property owners understand what renters have known for decades. We need an equitable eviction process. So we urge the committee's favorable report on SB 454. Thank you for your time.
Thank you, Mr. Shaw. Judge Davis? Judge Davis?
He's still on mute.
I know, I'm working on it.
Okay, there you go. Thank you, Senator Carter.
Thank you.
Mr.
Right, sorry for that. So I'm just hopping back in from another committee room here. So Senator Carter, did you just wrap up with Senate Bill 401?
we're off of that. We're on 40454, Senator Sidnor's bill, and we are on witness Judge Andre Davis.
Oh, okay, great. Thank you very much.
Happy to step back.
All right, thanks.
Thank you, Senator Carter, Mr. Chairman, Mr. Vice Chairman. Senators, thank you so much for this opportunity to request favorable treatment of Senate 454. I come to you as the former co-vice chair of the Attorney General's Access to Justice Task Force, of which many of you, if not all of you, are quite familiar by now. And the issues related to housing security were very much front and center of the considerations that the task force brought its hefty work to bring legislative and regulatory changes to improve housing security for the people of Maryland. As many of you know, I was a judge for 30 years, and I started my judicial career 33 years ago by spending a full year in what we then called landlord-tenant court here in Baltimore City, and actually around the state. And I will tell you, and many of you know this, 30 years ago, landlord-tenant jurisprudence was a hot mess. There was no equity. Tenants were treated awfully. There was an ethos, if you will, around landlord-tenant law that seemed to suggest that tenants simply, to use a word that was used in one of your earlier hearings, were simply deadbeats who didn't want to pay the rent. That's never been true, senators, and certainly it's not true today. People want to pay their rent. As the statistics that Mr. Countess shared with you in the earlier hearing, many of our citizens are paying significant percentages of their income in rent, and they want to get it paid. So fortunately, things have changed in the last 30 years. The General Assembly has made significant changes to the law. The Maryland Judiciary, through decisional development of the law, has made changes that have increased the equity and fairness and legitimacy, frankly, of our landlord-tenant jurisprudence and the system that is fair to both tenants as well as landlords. And this bill is another step along the way to true equity and fairness. Yes, there's a fiscal note. And
time.
Mr. Chairman, if I may have just 30 more seconds.
Absolutely. Yes, please.
There's a fiscal note, and my own view is that it is likely that the fiscal note will be less than the overall savings to the state if one is able to achieve a system where housing security, shelter security is maintained. The judiciary opposes the bill as drafted, it says, but what stands out in the judiciary's response is that this bill should be these responsibilities should be given to the executive branch. Respectfully, I say not so. Maryland has been on the forefront of mediation and ADR processes for well over 30 years. And under the leadership of former Chief Judge of current Chief Judge Morrissey in the District Court and Chief Judge Barbero on the Court of Appeals and her predecessor, Judge Robert Bell, the courts of Maryland are well equipped to do mediation, well equipped to put into effect a notice provision. And this system will work both for multi-unit landlords as well as for single unit residential properties. So again, I thank you for the time and the opportunity to address the bill, and I urge favorable recommendations.
Thank you very much,
Mr. Chairman.
Thank you, Judge Davis. And so now that concludes the testimony for the proponents of the bill. We'll now move on to the opposition panel. Yes, sorry.
We have one more witness, Mr. Merriam.
Okay. Chris, Ms. Merriam, my apologies. You're up next.
It's still on mute.
There you go.
All right, wasn't allowed to unmute myself there for a second. Sorry about that. Mr. Chair, Senator Carter, and members of the committee, my name is Chris Merriam. I am a Baltimore City landlord. I own and rent out 2 properties. I respectfully urge you to return a favorable report on SB 454. The bottom line for me is this: eviction is a catastrophe for tenants even in normal times. In a pandemic, it is all the more cruel and a public health disaster as well. Maryland's tenant landlord law is heavily biased in favor of landlords. This legislation would help balance the scales, providing more humane methods for resolving failure to pay rent cases, using eviction as an absolute last resort, as it should always be. I am currently using such a method, payment plans. A couple is renting out one of my houses. One is currently earning a low income. One is unemployed but looking for work. We have mutually agreed that they will pay me less than market rate while they search for a job, and that once their income increases, they will pay more. I'm covering my costs currently and earning a modest profit, even with a reduced rate. They are paying what they can and are avoiding eviction and achieving stability. Quite simply, this is the moral thing to do. Housing is one of the most basic human needs, along with food and water. Eviction is a cruel, traumatic process that has devastating impacts for the affected individuals and families, but also for their communities and even the whole state of Maryland. Even in the best of times, but especially in a pandemic, we should approach housing as a public health issue. People cannot reasonably be expected to quarantine or stay home if they do not have a stable home in which to stay. And because of the economic crisis, more people than ever are earning less money and struggling to pay their rent. The landlord lobby will claim that this legislation will devastate landlords. As a small landlord myself, SB 454 will not hinder my finances in any way. I recognize the landlord's right to evict a tenant in certain extreme cases. However, the vast majority of landlord-tenant disputes can and should be resolved in a more humane way, and this legislation provides for that. Thank you very much for your time.
Excellent. Thank you very much. And so, Senator Sinner, I see we have one more. I think Ms. Diamond, you are up next.
Good evening. Thank you so much, Chairman Smith, Vice Chair Waldstreicher, members of the committee. My name is Joanna Diamond with Healthcare for the Homeless, and I just want to underscore the impact that an eviction has on individuals and families and how prevention is the best method to end homelessness. For nearly 40 years, Healthcare for the Homeless has supported thousands of adults and families in their struggle to find safe and secure homes in Baltimore metropolitan area. And as part of our full integrated medical and behavioral health care, we provide permanent supportive housing to over 400 people every year. And in our efforts to ensure that all people are safely and securely housed, we strongly support SB 454. This is an opportunity to provide some structural changes that focus on preventing evictions on the front end as to avoid evictions and subsequent homelessness on the back end. We've been trying to address the affordable housing crisis for years, and the state has been taking some steps. They don't begin to touch the enormity of the problem. We can and must do better. The pandemic has only highlighted system inequities, especially when it comes to communities of color. Homelessness creates new health problems and exacerbates existing ones. And new research shows that evictions lead to increased COVID-19 infections and COVID-19 related deaths. By the time people come through our doors at Healthcare for the Homeless, they're already experiencing homelessness or unstable housing. And at that point, we can provide them services and connect them with stable housing. But it only makes sense to divert people and try to find them assistance they need before they get to us. This is why prevention is key. Currently, the rent court system traps renters in an unending cycle of debt. This body has recognized for years that diverting people to services in other contexts is a much more cost-effective and successful solution. This bill creates a common sense approach to eviction prevention and makes a more effective use of our legal system. Instead of using the courts as a mechanism for rent collection, this bill uses the court as a door to get people the assistance they need to maintain housing. It directs people to services up front, not doing it after someone has already lost their home. There is nothing more important to a person's health and safety than a stable home. Thank you for your time, and we urge a favorable report on SB 454.
Excellent. Thank you, Ms. Diamond. So then that, Senator Sinner, I think, concludes the testimony for the proponents. We'll now switch over to the opposition panel. And we will start off with Chief Judge Morsi. Chief Judge, you're up next.
Good afternoon, Chair Smith, members of the committee. For the record, my name is John Morrissey, and I'm the Chief Judge of the District Court of Maryland. The judiciary opposed the Senate Bill 454. Among the many wide sweeping changes to the current business process of the court, this bill would require the district court to establish and operate an eviction diversion program. And I don't want to disagree with my colleague, the Honorable Judge that just appeared, Andre Davis, but I really do feel that the provisioning of social services, counseling, financial assistance, and civil legal aid, while admirable and needed, are all non-judiciary functions. A program providing these functions would more appropriately be housed outside of the judiciary. Hopefully, a non-judiciary run program could reach individuals in need prior to the filing of suit, and that's important. But it could also serve as additional referral source for the district court once suit has been filed. So you want to try to reach them before suit has been filed, not once suit has been filed. The district court already operates an alternative dispute resolution mediation program that either the landlord or the tenant can avail themselves of today. In a number of courthouses, a lawyer of the day program is being operated by outside providers, and the Self-Help Center provides free legal advice for individuals with housing issues. The Self-Help Centers have handled more than 16,000 calls, walk-in chats, videos, and emails from March through the end of the year. Most courthouses simply lack sufficient space to house any other further programs or offices. In addition, this bill would fundamentally alter the district court process for the handling of failure to pay rent cases. The bill would require the court to screen all cases by conducting a status conference prior to trial. In fiscal 2020, the district court received over 509,000 failure to pay rent filings. This was off by about 160,000 filings from fiscal 19 as a result of the pandemic and restriction to operations. The fiscal impact will be significant in basically doubling the number of hearings required for failure to pay rent case types. This will negatively affect all other case types in terms of time standards management. Moreover, the number of individuals that appear for trial in fiscal 20, and this is pretty consistent year to year, was a little over 3%. If only 3% of the people decide to contest their case by coming to court, it's unlikely there'll be a much greater compliance rate for both a status conference and a trial. The judiciary is not planned for the capital needs of expanding staff of the magnitude required to implement this bill. The judiciary further opposes Senate Bill 454 for additional reasons, including the mandatory requirements that curtail the proper discretion of a judge. This and other issues are detailed in our written testimony. Thank you, Chair and members of the committee. It's always nice to be before you.
Thank you, Chief Judge. Always good to see you. Next, we will go to Ms. Howard. I see you there. You're up next.
Thank you, Mr. Chair. Good afternoon, and thank you very much for allowing my testimony. I'd like to start out by saying that I'm representing both the Maryland Multi-Housing Association and my client, Regional Management, Inc. We are housing providers that provide homes and take pride in providing homes for all over 538,000 residents of the state of Maryland. We oppose this bill very much. It is, I think it bears having a little bit of background for the committee to understand where the failure to pay rent statute came from. It essentially was the brainchild of two gubernatorial task forces and landlord-tenant commissions that set out to provide a balance between the interests of landlords and in getting a rapid and income from and payment of rent, with the need for the tenant to have a definite system by which he or she could be heard through the courts with regard to any issues that may have occurred with the tenancy. This has been a balanced system with the best and most important feature being the tenant's right to redeem his property. Unlike other states around that surround Maryland, like Virginia, it was mentioned earlier, Maryland has the chance to redeem, the tenant had the chance to redeem over three times and sometimes 4 times, depending upon jurisdiction, to redeem their property by paying and staying. This is a very unique right, and it is a very important right of the failure to pay rent process. The other processes for ending leases do not have that feature. I have extensive testimony regarding this bill, but some of the highlights that cause us problems are the fact that, number one, not all jurisdictions in the state of Maryland will have these or will be eligible for these diversionary programs. And that unfortunately is a problem for larger landlords who have holdings in cross jurisdictions. We do not think that will provide them with a that prevents fair housing or presents fair housing issues. There is also the other problems with the bill include I'm sorry. Well, I will certainly wind up my testimony. I would refer you to the very extensive testimony that we have put in writing, and I believe that it will become crystal clear why this is not a bill that we can support.
Okay, thank you very much, Ms. Howard. I do have one other member of the opposition signed up, but it's not here, Mr. Castilli. So that'll conclude the testimony. We'll switch over to questions from the committee. And seeing none, actually, Senator West, here you go. You're up. There you go.
Mr. Chair, well, since we have Judge Morrissey with us, and he sort of ran out of time before he could discuss elements of the judiciary's opposition. Let me ask a couple of questions of Judge Morrissey. Has the judiciary tried to figure out how many more employees it would have to hire in order to staff this program if the bill should be passed?
I believe it's in our fiscal notes, Senator West. It is kind of hard to estimate. I typically don't like to institute a program in Baltimore City that I can't institute in Garrett County. It's the district court, we're a unified state system. It's the division. I have no problem with an eviction diversion program. It's just, it really shouldn't be in the judiciary. It should be one of Mr. Zephyr's group or one of the other nonprofits that's out there that can pull all these providers together and offer them as a resource to the tenants. And hopefully that would occur before they file suit so that they can work these things out without having to file them. Once they enter the court system, all the bad things that go along with that happen.
So at the very end, you talked about courthouses may not have physical space to house the program. Have you done an inventory of the courthouses to conclude how many of the courthouses would have enough space and how many would not have enough space?
I don't have an exact number for you, but I can tell you, I could go through each one right now and tell you one way or the other, and I can certainly get you a list of those, Senator West. But I can tell you that there's this Day of Lawyer program we initiated in Baltimore City a number of years ago, and then one of the legal groups has given grants to certain other providers, and we expanded it to Prince George's County, and we had a heck of a time finding space in Prince George's in the Hyattsville. Just to give you an example, Baltimore County, if you've ever been to our Essex courthouse, which does hold landlord-tenant cases, there is not 1 ounce of available space in that courthouse to do anything. We've outgrown it. It needs to be replaced, quite frankly. And I don't know where I'd put these people. I actually have no idea. I wouldn't be able to do it there. We'd have to alter it so that people would no longer be able to come to Essex. They'd have to drive to Towson or Catonsville. And I don't even know if I have space in Towson, quite frankly. I wouldn't Catonsville.
Let me talk about the Maryland Mediation Confidentiality Act. I've had some experience with that during the course of my legal career. You state that the language in the bill would be inconsistent with the existing statute and the Maryland rule, accompanying Maryland rule. Could you elaborate on that?
That's my mediation department giving the ADR department here in the district court that takes their job very, very seriously, and they abide by. They have a problem with the words affirmative good faith efforts to resolve the claim, and that could somehow disclose efforts between the parties to resolve it. Most settlement agreements are all matters in settlement aren't to be disclosed before the judge when they come in. I can't hear those things. And
I
that's
used to be
for
one
both
of the
companies.
volunteer mediators in the Baltimore City Circuit Court, and I know that the first thing I told the people who came in to sit down and discuss the case with me is that nothing that they discuss in the mediation would find its way into the purview of the judge.
That's their concern.
And then lastly, in your last paragraph, very briefly, you say, quote, "The status conference provision in this bill is not workable." Can you discuss why it's not workable?
Well, that's what I mentioned by the sheer volume of the numbers. There's a number of bills pending before the court that will, before the legislature that will alter the landlord tenant. It's kind of hard to predict what way you guys are going to go, but if I even use a baseline of what we did this year, 500,000 filings, that's a second hearing. So that's 500,000 more court appearances. And we're just not designed to do that right now. The more volume that comes in, the longer the case delay is. We're already going to be dealing with massive backlogs in all of our case types and trying to work our way out of that. And to add another 500,000 cases would create it would be problematic for us.
Thank you very much for your testimony.
Excellent. Thank you, Senator West. Senator Castley has a question.
Thank you, Mr. Chairman. Mine, I guess first would be for Ms. Howard. Have you all looked to see exactly how the timing, the sequence of events that's set forth in this bill would impact the timing of how long it would take for the landlord to actually obtain any relief?
Yes, we have, and we're very concerned about that. The average time, although the statutory time seems to be very quick, in practice it is very, very slow. In Baltimore City, it takes at least 30 days. It would take between 20 and 30 days just to get a trial date once you file a failure to pay rent. And then the time elongates from there to getting the eviction scheduled. It can take upwards of 60 to 90 days to get from filing your case to actually getting a judgment and getting a writ and getting the sheriff to schedule the eviction. That's an awfully long time for you to wait for your monthly rent. By that time, your tenant is, generally speaking, not just owing you 1 month's rent, but is also owing you multiple months' rent. The additional procedures in this particular bill will add a good deal of time to that, and probably making it more like 120 days, because you have to go through this process where you have a pre-trial hearing, if you will, that then if you miss it, if the tenant misses it, then it's going to cause you have to either start over again or continue the process. There are additional things that need additional notices that have to be done, negotiations that you have to engage in, potential payment plan negotiations that you have to engage in, which just elongates the process and and it does not, I don't think, serve either party to have this system elongated in that way. It is not necessarily going to be healthy for the tenant or for the landlord, because at some point they're going to, in this process, things will fall apart.
Well, so just so I understand, under the current system in Baltimore, it takes 60 to 90 days from the time the landlord files until they can get the writ of eviction.
Until they can get both the writ of eviction and to schedule the eviction, that writ, with the sheriff's office.
So then how long does that usually take?
It truly depends on the volume of the sheriff's office,
Volume of the
but
sheriff.
that can take at least another 30 days. We also have in Baltimore a unique system where there is an additional post writ filing notice that must go out to the tenant to tell them exactly when their eviction is going to be held. That you have to give them 14 days notice, and again, a 7-day notice of when the eviction is actually scheduled, which does add another half a month period of time to whatever additional time you've already spent trying to get to that point.
So I'm just jotting down what you're saying. It appears that what you're telling me is that tenant doesn't pay today, January 1st, he doesn't pay, that probably what I'm looking about is January, February, March, April, end of April would be the eviction, where the tenant's actually out of the apartment, correct? Is that about right?
That is what we are concerned about, yes. And that
Okay.
is, and right now,
But that's what
right
you've
now,
got
we
now,
don't have
though.
any evictions, but in a normal course, it would be March or April before you would actually be able to regain that property, possession
Okay.
of that property.
And the tenant in Baltimore has 4 times they can redeem the property, right?
Yes, they have 4 times, the rest of the
Which
state has
means
3.
in a given year, if it takes me 4 months to get you out to trying to get an eviction, the tenant can walk in anytime before the eviction and say, well, here's the rent and you can't evict, right?
That's correct.
So a tenant could simply pay the rent 3 or 4 times a year under the current way the law works, right?
That is a very real possibility, and it would be then up to the landlord to decide whether or not to file to have that very important right foreclosed.
Do the landlords have a problem with I was looking at the Virginia statute on the diversion program, and it appears, if I'm looking at the right statute, it's the Virginia statute. It only applies in certain jurisdictions in Virginia, and that it's a voluntary program for the tenant has to put up 25% of the rent due. And if they'll do that, then the landlord can say, okay, I'll take this and we'll go into voluntary diversion program. But ours doesn't give you that choice, right? We just say, hey, you have to go in this diversion program automatically, and puts this bureaucracy in front.
Yes, under this bill, it would be mandatory. There would be no choice. And I might add that Judge Morrissey is absolutely correct about the success of the voluntary programs that have been operating in the court system right now. Both landlords and tenants engage in that program voluntarily. Sometimes it works, sometimes it doesn't, but that is a very robust program that has been housed in the district court. But putting something like the procedures that are listed in this bill as a mandate on the landlord and a mandate on the tenant, I might add, is not going to assist in creating and keeping the balance that we've had under this failure to pay rent statute for over 40 years.
Thank you, Ms. Howard. Thank you, Mr. Chairman.
Thank you, Senator Cassidy. We'll go to Senator Carter.
Thank you, Mr. Chair. My first question is for Mr. Shaw. Mr. Shaw, Ms. Howard just spoke elaborately about the current process and how we would lose balance if we implemented the changes under the bill. It's my understanding that there are some jurisdictions that already have these processes. And so can you explain how, where these provisions already exist, the difference between those jurisdictions and where we don't have it, and the impact and why we need the bill? What the bill would do to fix this, to create more of a balance?
Thank you, Senator. So I disagree with Ms. Howard's presentation of facts about the length of time it takes to proceed with eviction. At the level of statute, the statute provides that there'll be a trial within 5 days after filing the complaint, not even after service of process. And in reality, you know, if you're in Anne Arundel County, that looks like 7 to 8 days after filing. If you're in Baltimore City, That's more like 10 to 12 days after filing. It varies throughout the state, but what is quite certain and uniform is that across most of the state, your constituents will have to be ready for a trial in a failure to pay rent case within a week to 2 weeks. And the process can be surprising given that the summons is only by posting and mailing, and it may not be certain. So what do other jurisdictions do? In the 2016 summer study we had about rent court process, Judge Skirty, Mark Skirty, who helmed that study, educated all of us, landlord advocates, tenant advocates, about what New York City's housing court does, which is to triage litigants who come to court and provide what they call the resolution part, which is the opportunity that we've adopted in this legislation to have a judge interface with litigants before a trial date. And in New York City, with a high volume of cases, they do provide that opportunity for judges to understand what the parties are doing, order a mediation if the judge deems it appropriate, or schedule a trial date at a later time. And that's exactly what we do here. That's exactly what the Massachusetts Eviction Diversion Initiative this year has started doing. And this is a trend. Eviction diversion is a concept gaining traction across the country. And, Maryland can lead the way here. I think that the concepts in this bill are fundamentally sound, and the technical parts can be worked out if, for instance, Judge Morrissey or Maryland Multi-Housing Association have sincere interest in making these concepts work. But the idea that we can do nothing differently is just unacceptable to your constituents. We have 5 eviction actions filed for every cost-burdened household in this state. It's just, look, if I could put it this way, the court system, when I started doing advocacy at Public Justice Center, was dealing with 616,000 failure to pay rent cases a year. And that was in 2013. Now, in the past fiscal year, we had almost 670,000. This is not a system that is being fixed through voluntary happenstance programs. I appreciate that Judge Morrissey, in his leadership, has seen volunteer lawyer of the day programs, ADR programs at certain courts at certain times that are subject to, let's be honest, vacillations in the interest of the judges sitting on the dockets. We've got to enshrine these concepts so that at a structural level, a systemic level across Maryland, renters know what they can rely on, and landlords as well.
All right, excellent.
Mr. Chair, one more question, if I may. So my question, Judge Morrissey, you spoke about the cost of an eviction diversion program, and I was wondering if you could give us an idea of what cost the judiciary already incurs with the current processes that are in place, some of which Mr. Shaw just mentioned, with the pro bono attorneys and volunteer attorney programs, the ADR programs, and the myriad of other mediation programs and the like.
So thank you. That's a good question, Senator. Just to go back on Mr. Shaw, we actually give him space in our civil courthouse in Baltimore City so he can operate his program that he operates, I believe, every day there. Is that right, Mr. Shaw? In any event,
we do have someone there every
that is one of the myriad of different items that we've brought to bear to try to make the system as fair as possible on it. We fund through a grant the program in Baltimore City as it was a pilot, which is normally the way I do things. And then I try to expand it out to the best I can. And so that runs about, I believe, $140 for that program. And we monitor that, and Pam Ortiz, I think, who you all know, runs that program for me through the Access to Justice Department in the Judiciary, and her and Lonnie do a fantastic job in running those programs. They also run the self-help centers through that program, and that's just an outstanding program. The other day of court programs are all funded by grants from one of the other providers who we've worked collaboratively with to try to assist them. If people want to do these things, we'll try our best to accommodate them. I'm not in disagreement with solutions that would resolve issues before coming to court, but that's kind of the limit that the judiciary can get involved in. We can't favor one side or the other. We have to be neutral because that's our job. I don't know if that answers your question, Senator Carter.
It's close. So I guess that's it for now, Judge Morrissey, because I don't know if I'm allowed to ask you the question I'm wanting to ask you, or if you'll give me an answer. But given the high cost to the state of these evictions, given the judiciary's role in the current dysfunctional process, I'm just wondering what, if you don't like the eviction diversion idea, what would you suggest that would not be, you would not find offensive to the judiciary that could help us with this process?
I can't recommend, you do this to me every time I testify, Senator Carter. I certainly have ideas. I mean, there are things that can be done. We already do some of these things, and I think people don't recognize that that's what we do by things like offering mediation. Only 3% of the people actually show up for a court date. They do get notice. We check to make sure that the sheriff has posted on the property. We won't go forward with a case where we don't have that notation on the case. And so, we do offer these services. Like I said, if there's outside providers that want to group together an eviction diversion program, and that is a source of referral, we'd be happy to do that upon request. But to insist, the idea of forcing everyone into that doesn't fit for every case that I see. I sat in landlord-tenant court in Prince George's County for more than 8 years, and I've done thousands of these cases, and they're all different. Some of them are very amenable to mediation and ADR. Some of them, there's not a chance that that's ever going to work.
Thank you.
Thank you.
Thank you, Senator Carter. Senator Castley, you're up.
Thank you, Chair. I just want to get a couple of clarifications from Judge Morrissey, because we're going back and forth around, and now I'm just a little bit confused. But Judge, so if I remember the first part of your testimony, I think we have like 650,000 of these in a year.
Well, that was in fiscal 19. In fiscal 20, that ended June of this past year, ended at the end of June, we were down to 509,000. That was directly relatable to the conditions that we had to take in the beginning of March. Gotcha. In restrict operations. So, it almost works out. If you do the numbers, it'll work out perfectly.
It's an anomaly. This year was an anomaly. Hopefully, we hope it's an anomaly.
Well, it'll be less this year too. For this fiscal year, this will be a number that you can't really rely on going forward.
Okay. But of the 650,000, are you saying that out of that, only 3% of the tenants actually show up on the trial date?
That's correct.
Well, what about landlords? Do they show up at the same percentages, or?
The larger landlords, and Ms. Howard can probably talk to this better than I can, the larger landlords, if they don't show up, the case will be dismissed. They do submit a lot of dismissals either prior to court or when they show up on the day of court. So there's usually about a 25% dismissal rate of those cases prior to the court hearing them or at court. Mm-hmm. And then out of that, there's about, so out of 509,000, about 33% end up in a warrant of restitution, that means they've gotten a judgment. There's another there's this 66 other percent that were either dismissed at trial or before trial, or the landlord got paid, I would think, or the tenant moved out because they never did request a warrant of restitution for whatever reasons. So about a third go to warrants, and then about 3% of them end up in evictions themselves. So it's 3% of 3%. Well, it's 3% evictions, pretty much statewide, and that's been pretty consistent for the last couple of years.
And the bill has requirements for a number of, a lot of notices that have to go out to the landlord or by the landlord to the tenant, be affixed to the door, go out in mail. I guess every month, if the tenant's delinquent every month, it would appear that perhaps the landlord has to send the same notice saying, here's what your rights are, here's the programs, here's the diversion programs, and put it on your door and in your mail every month, if the tenant's late every month, doesn't in the courts, don't we provide the tenants with a pamphlet of all the various programs that are available to assist a delinquent tenant?
We do. We have those in the clerk's office. There are pamphlets. Again, Miss Ortiz from our Access to Justice Department in the AOC make sure that our websites are up to date. We have pages for both landlords and tenants with all the rights and resources that are available to them. I've been working recently with Secretary Holt as recently as today to try to figure out, the state received $402 million in rental assistance funding. Some of that money went directly to the 6 largest counties. Some went to the Secretary of Housing, and he's trying to promote those resources out there. And I'm trying to figure out ways to assist him in doing that. And I've encouraged everyone I've talked to, and I think everyone on this that's interested in any of these issues would agree that that's probably the number one priority right now in assisting both landlords and tenants to work themselves out of this situation. If we can get the money to the landlord and the tenant's rent satisfied, people stay in place, they're not subject to eviction. And don't get me wrong, I don't want to see anybody evicted during a pandemic or any other time, really. But that's the key, and that stops them. I have a self-interest because then that stops them from filing in court. And so it's a win-win-win all the way around, and that's a lot of money. And I know the secretary's committed. I can't speak for him, but I know he's on it, and he's trying to figure out how he can get people matching these resources to the need.
And I guess sort of finally, Judge, the process was just, I mean, you're a judge. You're taking oath to the Constitution and the laws. It's been said that in this hearing that the current process is dysfunctional, and I'm just curious for your assessment of that. Are you in fact running a dysfunctional process?
The court follows the law. We implement programs and procedures in our court process according to what the statutes say. So it's not for me to say whether it's dysfunctional or not dysfunctional.
But that's not exactly true, though.
Is efficient.
That's not exactly true, Judge, because we've provided processes before, and the court has shut us down. For example, the court said you've got to provide an attorney in the initial appearances. We didn't say to do that. The court said, hey, we're going to impose the Constitution on you guys, and you've got to provide a lawyer. So I'm just curious it just seems to me that the court has not hesitated when they felt that they were being forced to do a process that didn't serve the citizens right. Seems like the court's certainly willing to step up and say, this is a dysfunctional or unconstitutional process. And it seems to me that if the court feels it is a dysfunctional process, you certainly have an obligation to tell us that we're running such a dysfunctional process.
And that would be the litigation process running its course. If anyone felt that the process was not proper or unconstitutional in any manner, they could appeal the decisions all the way up to the Court of Appeals, and Chief Judge Barbera and her court would rule on it. What's funny, Senator Cassidy, is I always thought it was President Miller that did that to us, and not the Court of Appeals. The Court of Appeals ruled it unconstitutional. They didn't say to place it in the district court.
Okay.
Right.
All right.
Senator Cassidy, thank you, Judge. So now we're going to Senator Hedelman.
Thank you very much, Mr. Chairman. I just wanted I do have a couple questions that I'd like to toss either to Zephyr or to Judge Davis. But I did want to just comment on something that that Judge Morrissey just said. And there is a group that is being put together to help advise and work with the Secretary of DHCD on exactly how that new incoming federal money is going to be directed. And I think that work is actually starting next week. And some members of this committee are going to participate in that process, along with some of our colleagues from the House. So, so there is going to be quite a lot of good input. Can you, Zephyr or Judge Davis, talk about why so few people show up for the proceedings? I mean, we do have this larger number of, 660 some thousands of filings, and then as Judge Morrissey just said, about 3% actually show. I mean, there are lots of complicated reasons why that is so, but I think it would be beneficial for this committee to hear about why that is.
Go ahead,
and then if you can also talk about how long it takes after someone is evicted to find housing and the challenges that they face. that would be helpful. Thanks.
So there are myriad issues with access to the court for working people. And our clients at Public Justice Center face hurdles such as the docket being scheduled at the same time they have to get their kids to school, or being scheduled at a time that doesn't allow them to get on the 1 or 2 buses that they have to take to get to the district court. Many tenants face the even larger issue, which is that they cannot take time off from their shift, losing that wage so that they can come to court and contest a case which either they believe is completely frivolous, or second, a case in which they have extreme doubt that they'll have a fair proceeding before a judge. And that's the culture that we have in Maryland, where cases are serially filed, subject to being dismissed at court, despite the fact that the tenant took off time to come, to the tune of 20 to 30% of cases. And there's just not, I don't think there's a lack of interest in defending against a case. I think that for most tenants, they believe that the case will be dismissed because of payment made, or they've been told by their property manager that they don't need to appear because payment has been made. That's, I think, the largest issue, that tenants see the court notice, as the landlords do, as almost like a dunning, like a collections letter, and not as a lawsuit. But that can quickly become detrimental to tenants, because when default judgments are entered, they begin to lose some rights, such as the right to exercise the right of redemption, or the right to file a rent escrow case based on the number of judges. To the second question about the length of time it takes to get housing, that can take months for many of our clients, even if they're in a dangerous, hazardous type of housing situation based on lack of safety or conditions. Even their strongest desire to leave isn't enough for them to be able to find housing. They are facing a couple issues. One is, again, the constraints on time and ability to find, to go out into the marketplace to find housing. Those constraints can be not only financial, but health and disability related. But additionally, the record created by all these serially filed cases is devastating to their legitimacy in the eyes of the next potential landlord. So having, for instance, 3 or 4 cases filed against you that were all default judgments, that where the tenant went ahead and paid perhaps after the judgment date, and continued to be housed, continued to pay the landlord, that record of information then harms the tenant's access, and it just becomes harder and harder to convince the next landlord that that they should overlook this history of litigation and focus instead on the fact that the tenant continued to make payments that were unfortunately late.
Thank you, Mr. Chairman.
Okay, excellent. Thank you. All right. Looking around the room, seeing no further questions, that will conclude the hearing for Senate Bill 454. We'll now move on to our final bill of the day. Chief Judge.
No, I was just saying goodbye. I was saying goodbye to everyone, waving goodbye. Sorry.
Well, God bless you. Get to leave early. There you go.
Take care.
Right. Have a good one. All right. So we'll now move on. That concludes for Senate 454. Now move on to Senate Bill 455. Senator Sidnor, you are up.
All right. Thank you, Mr. Chair. It is just about 6 p.m. So my testimony is going to be very streamlined. Senate Bill 455 is essentially, well, the bill, what it does is extends the time for filing from 180 days to 300 days, allowing employees facing discrimination from more time in which to recover from a discriminatory event and to obtain assistance and to take action against that discrimination. Extending the filing time in Maryland to 300 days will also put the state in sync with federal law, which permits employees 300 days to file an employment discrimination complaint in the event that they have already filed a complaint with their local or state agency. That in of itself is a synopsis of this. You have my written testimony. With that, I'd like to turn this bill over to Ms. Michelle Siri, who's our lead proponent. And I am not certain if Mr. Flower, but with that, I'll rest and I look for a favorable.
Excellent. Thank you, Senator Sidnor. And Ms. Siri, you are the primary witness, and so you'll have 5 minutes. Good to see you, and go try.
Thank you so much. Good evening, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, my name is Michelle Siri. I'm the Executive Director of the Women's Law Center of Maryland, here to urge a favorable report on SB 455. So you all know us as a statewide nonprofit law firm, primarily serving survivors of domestic violence. But we are also the operators of one of the only, if not the only, statewide hotline for employment law. And I, of course, had a background for many, many years as a litigator in labor and employment law. And through our volunteer attorneys operating just one morning a week, we talk to about 600 Marylanders a year, answering questions from hostile work environment to lost wages and really everything in between. And we engage in issue spotting, we assist with self-represented litigant tasks, and when appropriate, we refer callers to our panel of volunteer attorneys who can help possibly represent the individuals. As Senator Sidnor says, this bill is pretty simple in what it does. It brings us in line with the federal law. It moves us from 6 months to 300 days. And really, it does three things. It gives employees time to work with their employers to resolve these issues without trying to simultaneously go through the administrative route, which can often look to employers as if the employee is not working in good faith and can really hinder any real progress that the employee might be able to make. It also gives employees who have exhausted those options time to find an attorney, a critical, obviously, component that not only helps the employee, but I think we would all, any of us that are practitioners would agree would help really all the parties and the court process run smoothly. And then third, as Senator Sidnor said, it puts Maryland in line with the federal process, which only really, the way it's set up now, just creates confusion for both the litigants and also the employers. I'd have to say, any argument that employers would be, put off guard by this, that 6 months is just enough and 300 days is way too much time, is really kind of not, I would say, not true, because the employers already are working under that 300-day for most of the situations, anything that would be able to be filed in federal court. So going back to the calls that we get, I just want to kind of point out that one of the most frequent calls that we get are related to discrimination. And every single caller, the first question we pretty much ask them is, when did this incident occur? Because of this time limitation. And we have to go through and explain to them the very confusing, well, if you're going to make a federal claim, you can do 300 days. If you're going to stay with a state claim, you can only do 6 months. And then we have to kind of figure out, which would be better, what kind of actions they have. Many of them might have an ability to go to federal court, but if they're bringing a claim based on marital status or natural hairstyles, for example, which thankfully, thanks to the work of this committee, the Crown Act last year, it's now illegal to discriminate based on natural hairstyles, then they would only be able to file in state court and go through the state process, and they would only have those 6 months. And that's really not a long time in the legal world. From the date the incident occurs, employees may have spend several months just trying to work internally, as I said, trying to resolve the matter. They might have more immediate concerns than the legal issue, just trying to find a new job or obtain unemployment benefits. And then, they finally decide they have to find a lawyer, and they're going to run around, and it's a process. It's a really long process. There's lots of great legal services organizations out there, but there's not a ton that can do employment law for a variety of reasons. And so by the time they come to us, 4 months maybe at the best case scenario has passed, they call us. It takes us several weeks for us to match them up with panel attorneys, several more weeks for them to determine if they can take the case. Best case scenario, we're talking 5 months out, but very few calls are actually best case scenarios. And we often have people that are much closer to that year mark, and we have to tell people that it's too late for them to file a state claim and that they don't have options. And so again, for all of those reasons, again, it gives them time to resolve things. It gives employees time to find an attorney, and it puts us in line with the federal process. we would urge a favorable report. And I would also actually say one more quick thing, which is that the General Assembly did pass within the past couple of years an expansion of harassment laws. So this bill would not include harassment to 2 years. And as we suspected, there has not been a huge tidal wave of cases. So we don't think that this is going to just open the floodgates and have tons and tons of people. It's really just going to help those folks that are on the cusp. And again, for all of those reasons, we urge a favorable report on SB 455. Thank you.
All right, thank you very much. Good to see you, Ms. Siri. And then so now we'll move over to Ms. Hughes. You are up.
Good evening, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Glendora Hughes, General Counsel from the Maryland Commission on Civil Rights, which this bill amends and will, as previously stated, change the coverage for stats, their limitations for employment, but also for public accommodations from 6 months to 300 days. And why the 300-day is that as a fair employment practice agency in the state, EEOC recognizes us, and therefore it triggers this rule, 300-day rule, which is the source of some of the confusion. So when we get a complaint, if it is beyond our 6-month statute of limitations, then we can transfer the case to EEOC, who is our federal partner, and we share a work sharing agreement, and which EEOC reimburses us for investigating cases that are within our jurisdiction and are timely filed. What has been done is that if a case is under Title VII, we transfer it to EEOC, or the person has to go to EEOC and would be able to get their claim taken under the 300-day rule. But there are those complainants who are beyond the 6 months and don't fall under Title VII, that would be basically unable to take their complaints and would not have an alternative place to have their complaints taken. This would provide consistency, as was previously stated, that there would eliminate the confusion. It would be 300 days with the state as well as with EEOC, and that if they should transfer cases to us, which they do from time to time, we can investigate them. And then if we receive cases, we don't have to transfer them to EEOC. We can retain them and proceed with the investigation. And for these reasons, the Maryland Commission on Civil Rights respectfully asks for a favorable report.
Excellent. Thank you very much, Ms. Hughes. And then we'll end the final witness of the day with Mr. Flowers. Is Mr. Flowers here? Okay, do not see Mr. Flowers, Senator Sidnor. So then with that concludes the testimony for Senate Bill 455. Are there any questions from the panel? Great. All right. So with that'll conclude the hearing for Senate Bill 455 and our hearings for the day. However, as you all know, we have a work session. I know, Senator West. I know it's going to be tough. So look, we'll make sure that we streamline this. We'll have as quick as we can. We left off. We were in the middle of the Law Enforcement Officers Bill of Rights review. We are going to push. So let's do this in 15 minutes. A link will be sent to your computers, and you already have it. Never mind. And we will be out of there within an hour. Okay, an hour. Just give me one more hour today, and we'll push. All right. I love you guys. 2 more weeks. 2 more weeks. All right. I'll see you all in 15.